Paper, Drafting, Pleading, and Conveyance 1. Question 1, Fundamental Principles of Pleading, Particulars in Plain and Written Statement. What are the fundamental principles of pleading? What particulars a plain and written statement must contain? Fundamental principles of pleading. Pleading is defined under Order 6, Rule 1 of the CPC as a plain or written statement. The primary objective is to clearly state the facts constituting the cause of action or defense, enabling the court and the opposing party to understand the case. The following principles, derived from the CPC and judicial interpretations, govern effective pleading. Principle of clarity and precision. Order 6, Rule 2 mandates that pleadings must contain a concise statement of material facts, avoiding unnecessary details. Clarity ensures that the court can identify the issues without ambiguity. For instance, in a suit for recovery of money, the plaintiff must specify the exact amount, the date of the transaction, and the basis of the claim, e.g., contract or loan. Principle of material facts. Pleadings must include all material facts necessary to establish the cause of action or defense. Order 6, Rule 2. Material facts are those essential to the claim or defense, excluding evidence or legal arguments. In Salem Advocate Bar Association, the Supreme Court emphasized that omitting material facts can lead to dismissal of the suit for lack of a cause of action. Principle of no evidence or law. Order 6, Rule 2 prohibits pleadings from containing evidence or legal arguments. Pleadings focus on facts, leaving evidence to be adduced during trial and legal arguments to be presented in court. For example, in a suit for specific performance, the plaintiff should state the agreement's terms but not include witness statements or case law. Principle of conciseness. Pleadings must be concise yet comprehensive. Order 6, Rule 2. Lengthy or vague pleadings can obscure issues, delaying justice. The Salem Advocate Bar Association case highlighted amendments to the CPC, e.g., Order 6, Rule 17, to curb frivolous or verbose pleadings, promoting efficiency. Principle of alternative and inconsistent pleadings. Order 6, Rule 7 allows parties to plead alternative or inconsistent facts, provided they are clearly distinguished. For example, a defendant may deny a contract's existence but alternatively claim it was void due to fraud, ensuring all defenses are covered. 2. Principle of verification. Order 6, Rule 15 requires pleadings to be verified by the party or their authorized representative, confirming the truth of the statements to the best of their knowledge. False verification can lead to penalties under the CPC. Principle of amendment. Order 6, Rule 17 permits amendments to pleadings to include new facts or correct errors, subject to the court's discretion. In Salem Advocate Bar Association, the Supreme Court clarified that amendments should be allowed if they do not alter the suit's nature or cause prejudice, balancing flexibility with fairness. Particulars of a plaint. The plaint, filed by the plaintiff, initiates a civil suit and must comply with Order 7 of the CPC. It is the first formal statement of the plaintiff's claim, and its contents determine the scope of the litigation. The essential particulars include: heading and title. The plaint must specify the court's name, jurisdiction, and case number, along with the parties' names, addresses, system, and descriptions. Order 7, Rule 1. For example, in the Court of the District Judge, New Delhi Civil Suit No. ___ of 2025 Mr. Anil Kumar Sharma. Plaintiff vs. Mr. Rajesh Kumar. Defendant name and description of parties' full names, addresses, and descriptions of the plaintiff and defendant, ensuring clarity in identification. Order 7, Rule 1, A. Facts constituting the cause of action. A clear statement of the facts giving rise to the plaintiff's claim. Order 7, Rule 1, B. For example, in a suit for breach of contract, the plaintiff must detail the agreement, its terms, and the breach. Facts establishing jurisdiction. The plaintiff must state facts showing the court's jurisdiction, such as the location of the cause of action or the party's residence. Order 7, Rule 1, C. 3. Relief claim. The specific relief sought, such as damages, injunction, or specific performance. Order 7, Rule 1, D. The relief must be precise, e.g., Rs 5,00,000 as damages. Valuation and court fees. The plaintiff must state the suit's valuation and confirm payment of court fees as per the Court Fees Act, 1870, Order 7, Rule 1, e. Verification. The plaintiff must be verified by the plaintiff, confirming the truth of the statements, Order 6, Rule 15. Additional particulars: date of cause of action, the date when the cause of action arose, Order 7, Rule 1, f. Statement of set-off or counterclaim, if applicable, any set-off or counterclaim must be stated. Advocate's details, the name and signature of the plaintiff's advocate, if represented. Particulars of a written statement. The written statement, filed by the defendant, responds to the plaintiff and is governed by Order 8 of the CPC. It must address each allegation and present the defense. The essential particulars include: response to allegations. The defendant must admit, deny, or plead insufficient knowledge for each allegation in the plaint, Order 8, Rule 3. Denials must be specific, not general, Order 8, Rule 5. New facts or defense. The defendant must state any new facts supporting their defense, such as fraud, mistake, or limitation, Order 8, Rule 2. Objections to jurisdiction or maintainability. Any preliminary objections, such as lack of jurisdiction or limitation, must be raised, Order 8, Rule 2. Set-off or counterclaim. If claiming a set-off or counterclaim, the defendant must provide details, including valuation and court fees, Order 8, Rule 6. Verification. The written statement must be verified by the defendant, Order 6, Rule 15. Relevance of Salem Advocate Bar Association. In Salem Advocate Bar Association, Tamil Nadu v. Union of India, 2005, 6 SCC 344, the Supreme Court addressed procedural reforms under the CPC, emphasizing the need for clear and concise forepleadings to expedite justice. The case upheld amendments to Order 6 and Order 8, which introduced stricter timelines for filing written statements, 30 days, extendable to 90 days, and limited amendments to pleadings to prevent delays. This case underscores the importance of adhering to procedural timelines to avoid dismissal. Ensuring pleadings are focused on material facts to streamline trials. Using amendments judiciously to correct genuine errors. Sample plaint. Below is a sample plaint for a suit for recovery of money, illustrating the required particulars. In the Court of the District Judge, New Delhi Civil Suit No. ____ of 2025 Mr. Anilkumar Sharma, S/O Mr. Ramesh Sharma, R/O 123, Green Park, New Delhi 110016. Plaintiff vs. Mr. Rajesh Kumar, S/O Mr. Suresh Kumar, R/O 456, Ashok Nagar, New Delhi 110018. Defendant plaint for recovery of money 1. The plaintiff is a resident of New Delhi and carries on business as a money lender. 2. The defendant approached the plaintiff on January 1, 2024, requesting a loan of Rs 5.3. The plaintiff advanced Rs 5,00,000 to the defendant on January 1, 2024, Vidya Prami 4. The defendant failed to repay the loan by July 1, 2024, despite repeated demands. 5. The cause of action arose on July 1, 2024, when the defendant defaulted on repayment. 6. This court has jurisdiction as the cause of action arose within its territorial limits. 7. The suit is valued at Rs 5,60,000, principal of Rs 5,00,000 plus interest of Rs 60,000 per year. The plaintiff prays that this honorable court may be pleased to A. Pass a decree for Rs 5,60,000 in favor of the plaintiff against the defendant. B. Award costs of the suit. C. Grant such other reliefs as deemed fit. Verification. Verified at New Delhi on this 15th day of June, 2025, that the contents of the above plain signature 5 Mr. Anilkumar Sharma plaintiff sample written statement below is a sample written statement responding to the above plaint. In the Court of the District Judge, New Delhi Civil Suit No. ____ of 2025 Mr. Anil Kumar Sharma. Plaintiff vs. Mr. Rajesh Kumar. Defendant Written Statement 1. Paragraph 1 of the plaint is admitted. 2. Paragraph 2 is denied. The defendant never executed a promissory note or agreed to 12%. 3. Paragraph 3 is denied. The defendant received Rs 2,00,000 as a friendly loan without I4. Paragraph 4 is denied. The defendant repaid Rs 2,00,000 on June 1, 2024, via Bank TR5. Paragraph 5 is denied as no cause of action exists due to full repayment. 6. The defendant objects to the suit's maintainability as the plaintiff has no cause of AC. 7. The defendant reserves the right to file a counterclaim if necessary. Verification, verified at New Delhi on this 30th day of June, 2025, that the contents of the above writ signature Mr. Rajesh Kumar defendant analysis of samples the sample plaint and written statement illustrate the principles of pleading, clarity. The plaint clearly states the loan amount, date, and breach, while the written statement specifically denies or admits each allegation. Material facts, the plaint details the loan agreement and default, while the written statement introduces the defense of repayment. No evidence or law, both documents avoid evidence, e.g., bank receipts, and legal arguments, focusing on facts. Verification, both are verified as per CPC requirements. 6. Practical considerations. Common mistakes to avoid: vague pleadings, failing to specify material facts can lead to dismissal, Order 7, Rule 11. Non-compliance with timelines, Order 8, Rule 1 mandates filing the written statement within 30 days, extendable to 90 days. Omission of jurisdiction, failing to establish the court's jurisdiction can result in rejection of the plaint. Examination tips, structure answers, begin with a discussion of Order 6, 7, and 8 of the CPC, followed by principles and examples. Cite case law, reference Salem Advocate Bar Association to demonstrate procedural awareness. Use samples, include sample pleadings to showcase practical application, ensuring all required particulars are covered. 7. Question 2. Interlocutory application and its essential elements. What is an interlocutory application? What are its essential elements? Defining interlocutory application. An interlocutory application is a formal request made to a court for an order or direction to address a specific issue arising during the course of litigation, without determining the final rights of the parties. As per the Code of Civil Procedure, 1908, CPC, interlocutory applications are governed primarily under Order XXXIX, for interim injunctions, Order 11, for discovery and inspection, and other provisions such as Sections 94 and 151, which provide courts with inherent powers to pass interim orders. These applications are incidental to the main proceeding and aim to ensure the smooth conduct of the case, protect the rights of parties, or prevent irreparable harm. The term interlocutory derives from the Latin word interlocutus, meaning spoken between or interim. Such applications are filed to address matters that cannot wait until the final judgment, such as seeking interim injunctions, stay orders, amendments to pleadings, or discovery of documents. They are distinct from the main pleadings, plaint or written statement, and are drafted to address specific, urgent, or procedural needs. Legal framework governing interlocutory applications. Interlocutory applications are primarily governed by the CPC, which provides a structured framework for their filing and adjudication. Key provisions include, Section 94, empowers courts to grant interim reliefs, such as injunctions or attachments, to prevent the ends of justice from being defeated. Section 151, grants courts inherent powers to pass orders necessary for justice, often used when no specific provision applies. Order XXXIX, Rules 1 and 2, deals with temporary injunctions to restrain acts that may cause irreparable injury or affect the subject matter of the suit. Order 7, Rule 11, allows applications for rejection of a plaint if it discloses no cause of action. Order 6, Rule 17, governs applications for amendment of pleadings. Additionally, specific statutes, such as the Specific Relief Act, 1963, and the Arbitration and Conciliation Act, 1996, may provide for interlocutory reliefs in specialized proceedings. For instance, Section 9 of the Arbitration Act allows parties to seek interim measures before or during arbitral proceedings. Essential elements of an interlocutory application. Drafting an interlocutory application requires meticulous attention to procedural and substantive requirements. The essential elements of an interlocutory application are as follows. 8.1. Title and cause. Title: the application must clearly state the court, case number, and parties involved, mirroring the cause title of the main suit. For example, in the Court of the District Judge, New Delhi, Civil Suit Number 123 of 2025, A versus B. 2. Identification of the applicant. The application must specify whether the applicant is the plaintiff, defendant, or a third party, along with their legal standing to file the application. 3. Prayer for relief. The application must articulate the specific interim relief sought, such as an injunction, stay, or amendment. The prayer should be concise and precise, avoiding ambiguity. 4. Grounds for relief. The applicant must provide legal and factual grounds justifying the relief. This includes citing relevant provisions of law, e.g., Order XXXIX, Rule 1, and demonstrating urgency or irreparable harm. 5. Affidavit in support. An affidavit, sworn by the applicant or their authorized representative, must accompany the application, verifying the truth of the facts stated. The affidavit should comply with the format prescribed under Order 19 of the CPC. 6. Court fee and jurisdiction. The application must include the requisite court fee as per the Court Fees Act, 1870, and confirm the court's jurisdiction to entertain the application. 7. Annex years and supporting documents. Relevant documents, such as copies of the plaint, written statement, or evidence supporting the claim, must be annexed. 8. Compliance with procedural rules. The application must adhere to the procedural requirements of the court, including proper formatting, numbering, and filing timelines. Drafting an interlocutory application. Practical considerations. Drafting an interlocutory application is an exercise in precision and persuasion. The drafter must ensure that the application is legally sound, factually accurate, and strategically compelling. Below is a sample format of an interlocutory application for a temporary injunction under Order XXXIX, Rules 1 and 2 of the CPC, in the Court of the District Civil Suit Number 123 of 2025. Plaintiff's name versus defendant's name. Judge, New Delhi, Plaintiff, Defendant. Interlocutory application under Order XXXIX, Rules 1 and 2. Read with Section 151 of CPC. Most respectfully showeth, 1. That the above-mentioned suit is pending before this honorable court and is fixed for he 9-2. That the plaintiff has filed the present suit for. Briefly state the cause of action, E3. That the plaintiff seeks an interim injunction to restrain the defendant from specific 4. That the plaintiff has a prima facie case, as evidenced by documents/evidence. 5. That the balance of convenience lies in favor of the plaintiff, and irreparable injury. 6. That this application is made bona fide and in the interest of justice. Prayer. It is most respectfully prayed that this honorable court may be pleased to, a. Grant an ad interim injunction restraining the defendant from specific act. b. Pass any other order as this honorable court deems fit. Place, New Delhi. Date advocate for the plaintiff. The affidavit accompanying the application would state, Affidavit I, plaintiff's name, age, resident of address, do hereby solemnly affirm and 1. That I am the plaintiff in the above suit and am fully conversant with the facts of the 2. That the contents of the accompanying application are true to my knowledge. 3. That no part of this affidavit is false, and nothing material has been concealed. Deponent verification. verified at New Delhi on date that the contents of this affidavit are true. Landmark case law analysis. Interlocutory applications, particularly for interim injunctions, have been the subject of significant judicial pronouncements in India. Two landmark cases illustrate their application and judicial scrutiny. Amarnath v. State of Haryana, 1977, Air 1977 SC 2185. In this case, the Supreme Court elucidated the principles governing the grant of interim injunctions under Order XXXIX, Rules 1 and 2. The court held that three essential conditions must be satisfied. Prima facie case, the applicant must demonstrate a strong initial case with a reasonable likelihood of success. Irreparable injury, the applicant must show that denial of the injunction would cause harm that cannot be adequately compensated by damages. Balance of convenience, the court must weigh the inconvenience to the applicant if the relief is denied against the inconvenience to the respondent if it is granted. 10. The court emphasized that interlocutory reliefs are discretionary and must be exercised judicially to prevent abuse of process. In this case, the application for an interim injunction was rejected due to the absence of a prima facie case, highlighting the importance of substantiating claims with evidence. Morgan Stanley Mutual Fund v. Kartik Das, 1994, 4 SCC 225. This case clarified the scope of interlocutory applications in the context of consumer disputes. The Supreme Court held that interim orders should not be granted mechanically and must consider the public interest, especially in financial or commercial matters. The court refused an interim injunction against the public issue of shares, noting that the balance of convenience favored the respondent and that granting the relief would cause disproportionate harm. This case underscores the need for careful drafting to address all three conditions, prima facie case, irreparable injury, and balance of convenience, in financial disputes. Types of interlocutory applications. Interlocutory applications encompass a wide range of reliefs, including but not limited to, temporary injunctions, Order XXXIX, Rules 1 and 2 to restrain acts that may alter the status quo or cause irreparable harm. Stay orders, Section 94 to halt proceedings or execution of orders pending appeal or review. Amendment of pleadings, Order 6, Rule 17 to modify the plaint or written statement to reflect new facts or correct errors. Discovery and inspection, Order 11 to compel the production of documents or answers to interrogatories. Rejection of plaint, Order 7, Rule 11 to dismiss a suit for lack of cause of action or jurisdiction. Appointment of receiver, Order XL to manage property during litigation. Each type requires specific drafting techniques, tailored to the relief sought and the legal provisions invoked. Challenges in drafting interlocutory applications. Drafting interlocutory applications poses several challenges, including, precision in language. The application must avoid vague or overly broad prayers, as courts may reject ambiguous requests. Evidentiary support, the applicant must provide cogent evidence, such as documents or affidavits, to substantiate claims. 11. Compliance with timelines, applications must be filed promptly, as delays may lead to the denial of relief, e.g., laches in seeking injunctions. Balancing interests, the drafter must anticipate counterarguments and address the balance of convenience effectively. 12. Question 3. Draft an anticipatory bail application. Draft an anticipatory bail application on behalf of Mr. Vikram Kohli, resident of 489, Shakti Nagar, Delhi, against whom an FIR stands registered at the Siddharth Nagar police station by his wife alleging harassment and cruelty for demand of dowry. Details of the applicant: name, Mr. Vikram Kohli. Age, 34 years. Occupation, software engineer, employed with Tech Innovations Private Limited, Delhi. Address, 489, Shakti Nagar, Delhi 110007. Contact, +91 987 654 3210. Family background, married to Mrs. Priya Kohli since 2018. One child aged 4 years. No prior criminal record. Details of the case: on May 20, 2025, and FIR, No. 123/2025, was registered at Siddharth Nagar Police Station, Delhi, based on a complaint by Mrs. Priya Kohli, the applicant's wife. The FIR alleges, 1. Cruelty and harassment, under Section 498A, IPC, for alleged mental and physical cruelty due to dowry demands. 2. Criminal breach of trust, under Section 406, IPC, for alleged misappropriation of Stradhan, wife's property. 3. Dowry demands, under Sections 3 and 4 of the Dowry Prohibition Act, 1961, for allegedly demanding dowry post-marriage. The applicant submits that these allegations are false, exaggerated, and motivated by matrimonial disputes arising from personal differences. The applicant has no history of violence or criminal activity and is willing to cooperate with the investigation. Legal framework for anticipatory bail. Section 438 of the CRPC empowers a High Court or Sessions Court to grant anticipatory bail to a person apprehending arrest for a non-bailable offense. The provision states, when any person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense, he may apply to the High Court or the Court of Session for a direction under this section. And that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. 13. Cors. The Supreme Court in Gurbakhsh Singh Sibia v. State of Punjab, Air 1980 SC 1632, laid down guiding principles for anticipatory bail, emphasizing that the discretion to grant bail should be exercised judiciously, considering factors such as the nature of the offense, the likelihood of the accused absconding, and the risk of evidence tampering. Grounds for anticipatory bail. The applicant submits the following grounds for the grant of anticipatory bail: prima facie case. The allegations in the FIR lack specificity and corroborative evidence. The complaint appears to be a reaction to ongoing matrimonial disputes, as evidenced by the applicant's peaceful cohabitation with his wife until recent disagreements. In Arnish Kumar v. State of Bihar, Air 2014 SC 2754, the Supreme Court cautioned against the misuse of Section 498A, noting that vague and general allegations without evidence warrant careful scrutiny. The applicant asserts that the allegations are vague and lack prima facie credibility. No criminal antecedents. The applicant has no prior criminal record and is a law-abiding citizen with a stable profession. This aligns with the principles in Sitaram Sadlingapam Hetra v. State, 2011, 1 SCC 694, where the Supreme Court held that the absence of criminal antecedents is a favorable factor for granting anticipatory bail. Cooperation with investigation. The applicant undertakes to cooperate fully with the investigation, including appearing before the investigating officer as required. The Supreme Court in Gurbakhsh Singh emphasized that anticipatory bail does not hinder investigation, provided the accused cooperates. Low risk of absconding. The applicant is a permanent resident of Delhi with deep ties to the community, including a stable job and family responsibilities. This minimizes the risk of absconding, a key consideration under Section 438, CRPC. Nature of allegations. The offenses alleged, Sections 498A, 400, and 6 IPC, and Sections 3/4 of the Dowry Prohibition Act, are punishable with imprisonment up to 7 years, making them eligible for anticipatory bail. The absence of specific evidence of physical harm or imminent danger supports the grant of bail, as per Sushila Agarwal v. State, NCT of Delhi, 2020, 5 SCC 1. 14. Supporting case law. The following landmark cases support the applicant's case: Gurbakhsh Singh Sibia v. State of Punjab, Air 1980 SC 1632. The Supreme Court held that anticipatory bail is a tool to protect personal liberty and prevent harassment through false accusations, provided the applicant demonstrates a genuine apprehension of arrest and a lack of mala fide intent. Arnish Kumar v. State of Bihar, Air 2014 SC 2754. The court emphasized the need to prevent automatic arrests in cases under Section 498A, especially when allegations appear motivated or exaggerated. Sushila Agarwal v. State, NCT of Delhi, 2020, 5 SCC 1 The court clarified that anticipatory bail can be granted without a fixed duration unless specific circumstances justify its limitation, supporting the applicant's request for unconditional bail. Anticipatory bail application in the Court of the Sessions Judge, Delhi application under Section 438 of the Code of Criminal Procedure, 1973, for anticipatory bail most respectfully showeth, 1. That the applicant, Mr. Vikram Kohli, aged 34 years, resident of 489, Shakti Nagar, Delhi 110,007, is a law-abiding citizen with no criminal antecedents. 2. That Inferno 123/2025 has been registered against the applicant at Siddharth Nagar Police Station, Delhi, under Sections 498A and 406 of the IPC and Sections 3 and 4 of the Dowry Prohibition Act, 1961, based on a complaint by the applicant's wife, Mrs. Priya Kohli, alleging harassment and cruelty for dowry demands. 3. That the allegations are false, baseless, and motivated by matrimonial disputes arising from personal differences between the applicant and the complainant. 4. That the applicant has a clean record, is gainfully employed, and has deep roots in the community, ensuring no risk of absconding. 5. That the applicant undertakes to cooperate fully with the investigation and comply with all lawful directions of the investigating authorities. 6. That the allegations lack specific evidence and appear to be an attempt to misuse the provisions of Section 498A, as cautioned by the Supreme Court in Arnish Kumar v. State of Bihar, Air 2014 SC 2754. 7. That the grant of anticipatory bail will not prejudice the investigation, as held in Gurbakh Sher Singh Sibia v. State of Punjab, Air 1980 SC 1632. 8. That the applicant apprehends arrest due to the non-bailable nature of the offences and seeks protection of his liberty under Section 438, CRPC prayer, it is, therefore, most respectfully prayed that this honourable court may be pleased to, 15, a. direct that, in the event of his arrest in connection with Furno 123/2025, the applicant, Mr. Vikram Kohli, be released on bail on such terms and conditions as this honourable court may deem fit. b. Pass any other or further orders as this honourable court may deem just and proper. And for this act of kindness, the applicant, as in duty bound, shall ever pray. Applicant, Mr. Vikram Kohli through advocate name of Advocate Delhi Bar Association contact, advocate's contact details date, June 15, 2025 supporting documents copy of Furno 123/2025. Identity proof of the applicant, Aadhaar card/PAN card. Employment certificate from Tech Innovations Private Limited affidavit of the applicant affirming the facts stated. Marriage certificate of the applicant and complainant. 16 Question 4, Revision and its differentiation from appeal, second appeal, and reference. What do you understand by revision? Explain how revision is different from appeal, second appeal, and reference. This analysis is structured to provide a comprehensive understanding of revision, its procedural nuances, and its differences from other appellate mechanisms, catering to the academic needs of a law student preparing for examinations. Concept of revision. Revision is a discretionary power vested in superior courts, such as high courts and sessions courts, to review the decisions of subordinate courts to ensure justice. It is not a right of a party but a supervisory jurisdiction exercised to correct errors of jurisdiction, illegality, or material irregularity that may lead to a miscarriage of justice. The scope of revision is narrower than that of an appeal, as it does not permit reappreciation of evidence unless necessary to address a jurisdictional issue. Revision under the Code of Civil Procedure, 1908 Section 115 of the CPC governs revisional jurisdiction in civil matters. It provides that the High Court may call for the record of any case decided by a subordinate court and revise the order if, 1. The subordinate court exercised jurisdiction not vested in it by law. 2. The subordinate court failed to exercise jurisdiction vested in it. 3. The subordinate court acted illegally or with material irregularity in the exercise of its jurisdiction. The Supreme Court in Mahindra and Mahindra Limited v. Union of India, Air 1979 SC 798, clarified that revisional jurisdiction is confined to correcting jurisdictional errors and does not extend to re-evaluating factual findings unless they are perverse or based on no evidence. Revision under the Code of Criminal Procedure, 1973 Sections 397 to 401 of the CRPC govern revisional powers in criminal matters. Section 397 empowers high courts and sessions courts to call for records of subordinate criminal courts to satisfy themselves as to the correctness, legality, or propriety of any finding, sentence, or order. Section 401 further delineates the High Court's powers in revision, allowing it to exercise powers akin to those in an appeal, subject to limitations. In Shankar Ramchandra Abhyankar v. Krishnaji Dattatreyabapat, Air 1970 SC1, the Supreme Court held that revisional jurisdiction in criminal matters is supervisory, aimed at preventing miscarriage of justice, and does not permit reappreciation of evidence unless a grave error is apparent. 17. Distinction between revision and appeal. An appeal and revision serve distinct purposes within the judicial framework, differing in scope, procedure, and effect. The following points highlight their differences. Nature and scope. An appeal is a statutory right provided to a party aggrieved by a decision to seek re-examination of the case on facts and law. It is governed by Sections 96 to 112 of the CPC for civil appeals and Sections 372 to 394 of the CRPC for criminal appeals. In contrast, revision is a discretionary power exercised by a superior court to correct jurisdictional or procedural errors, not to re-adjudicate the merits of the case. In Hari Shankar v. Rao Girdhari Lal Chowdhury, Air 1963 SC 698, the Supreme Court emphasized that an appellate court has wide powers to review evidence and law, whereas a revisional court is limited to jurisdictional issues. Right versus discretion. An appeal is a right conferred by statute, subject to conditions such as limitation periods and grounds specified in the CPC or CRPC. Revision, however, is not a right but a discretionary remedy, invoked either suo motu by the court or on an application by a party. The High Court may refuse to entertain a revision if no jurisdictional error is apparent, as held in Major S.S. Khanna v. Brigg F.J. Dillon, Air 1964 SC 497. Evidence and merits. In an appeal, the appellate court may reappreciate evidence, examine witnesses, and substitute its findings for those of the lower court. In revision, the court does not re-evaluate evidence unless necessary to correct a jurisdictional error or material irregularity. The Supreme Court in Pathumma v. Muhammad, Air 1986 SC 1436, reiterated that revisional courts should not act as appellate courts by reassessing factual disputes. Effect on lower court's decision. An appellate court's decision replaces the lower court's judgment, while a revisional court's order typically corrects errors without substituting the entire decision. In cases of revision, the matter may be remanded to the lower court for fresh consideration if a jurisdictional error is found. Distinction between revision and second appeal. A second appeal, provided under Section 100 of the CPC, differs significantly from revision, particularly in civil matters. The distinctions are as follows. 18 grounds of interference. A second appeal lies only on a substantial question of law, as clarified in Chanilal v. Mehta Sons Limited v. Century Spinning Manufacturing Co. Limited, Air 1962 SC 1314. Revision, under Section 115, is invoked for jurisdictional errors, illegality, or material irregularity, irrespective of whether a question of law is involved. Jurisdiction. A second appeal is heard by the High Court against a decree passed by a lower appellate court, while revision may be filed against any order or decree of a subordinate court, provided it meets the criteria under Section 115. The Supreme Court in Shakuntala Devi v. Kuntal Kumari, Air 1969 SC 575, held that a second appeal does not extend to questions of fact, unlike revision, which may address procedural irregularities. Scope of review. In a second appeal, the High Court is confined to legal questions, whereas in revision, the focus is on jurisdictional propriety. A revisional court may intervene even in interlocutory orders, whereas a second appeal typically lies against final decrees. Examples: for instance, in a second appeal, the High Court may examine whether the lower court misinterpreted a statutory provision, as in Santosh Hazare v. Purushottam Tiwari, 2001, 3 SCC 179. In a revision, the High Court may set aside an order if the lower court acted beyond its jurisdiction, as seen in Mahindra and Mahindra Limited v. Union of India, AIR 1979 SC 798. Distinction between revision and reference. Under Section 113 of the CPC and Section 395 of the CRPC, is another distinct mechanism from revision. The differences are outlined below. Nature and initiation: a reference is initiated by a subordinate court seeking the opinion of a superior court, typically the High Court, on a question of law arising during a case. Revision, however, is initiated either by a party or suo motu by the superior court to review a lower court's decision. In Rajagopala Rao v. SI of Police, AIR 1980 SC 1780, the Supreme Court clarified that a reference is a consultative process, unlike the supervisory nature of revision. Purpose: the purpose of a reference is to resolve doubts about the validity of a law or a legal question, ensuring uniform application. Revision aims to correct errors in the exercise of jurisdiction or 19 procedure. A reference does not challenge the lower court's decision but seeks guidance, whereas revision may lead to the setting aside of an order. Scope: a reference is limited to the specific question referred, while revision encompasses a broader review of the lower court's proceedings for jurisdictional errors. The High Court in a reference provides an opinion, which the referring court applies, whereas in revision, the High Court may directly interfere with the order. Examples: for example, a subordinate court may refer a question about the constitutionality of a statute under Section 113, CPC, as seen in hypothetical scenarios akin to State of Bombay v. Narothamdas Jethab High, AIR 1951 SC 69. In contrast, a revision may be filed to challenge an illegal order, such as in Shankar Ramchandra Abhyankar v. Krishnaji Dattatreyabapat, AIR 1970 SC 1. Practical application in drafting: in drafting a revision petition, a pleader must articulate the jurisdictional error, illegality, or material irregularity with precision, referencing statutory provisions and case law. Below is a sample draft of a revision petition to illustrate the principles discussed. Sample revision petition in the High Court of Delhi at New Delhi. Civil revision petition under Section 115 of the Code of Civil Procedure, 1908. Most respectfully Shauth, 1. That the petitioner is aggrieved by the order dated April 10, 2025, passed by the District Judge, Tis Hazare Courts, Delhi, in Civil Suit No. 456/2024, whereby the court dismissed the petitioner's application for amendment of the plaint. Under Order 6, Rule 17, CPC. 2. That the lower court failed to exercise jurisdiction vested in it by law, as the amendment sought was necessary to determine the real controversy between the parties, as held in Rajesh Kumar Agarwal v. KK Modi, 2006, 4 SCC 385. 3. That the dismissal of the application constitutes a material irregularity, as the lower court did not consider the liberal principles governing amendments, as elucidated in Rivajito Builders and Developers v. Narayanaswamy, 2009, 10 SCC 84. 4. That the impugned order has caused grave prejudice to the petitioner, leading to a potential miscarriage of justice. Prayer: a. Set aside the order dated April 10, 2025, passed by the District Judge, Tis Hazare Courts, Delhi. 20. B. Allow the petitioner's application for amendment of the plaint. C. Pass any other orders as this honorable court may deem fit. Petitioner: petitioner's name through, advocate's name. Delhi Bar Association. Date, June 15, 2025. 21. Question 5. Maintenance under Sector 125 CRPC and draft application. Who are entitled for maintenance under Sector 125 of Criminal Procedure Code, 1973? Explain the procedure for the enforcement of maintenance order. Draft an application of maintenance under Sector 125 Criminal Procedure Code. Persons entitled to maintenance under Section 125 CRPC Section 125, 1, of the CRPC delineates the categories of individuals who may claim maintenance from a person having sufficient means but who neglects or refuses to maintain them. These include, 1. Wife. A legally wedded wife who is unable to maintain herself is entitled to maintenance from her husband. The term wife includes a woman whose marriage is valid under the applicable personal laws or, in certain cases, a woman in a void or voidable marriage, provided she has not remarried. The Supreme Court in Savitaben Somabai Bhatia v. State of Gujarat, 2005, 3 SCC 636 clarified that even a woman in a void marriage may claim maintenance if she was unaware of the legal impediment at the time of marriage. However, a wife living in adultery or who has voluntarily separated without sufficient cause is not entitled to maintenance, Section 125, 4. 2. Legitimate or illegitimate minor child. A minor child, whether legitimate or illegitimate, who is unable to maintain itself, is entitled to maintenance from the father or mother, as the case may be. The term minor refers to a person below 18 years of age, as per the Indian Majority Act, 1875. In Nanak Chand v Chandra Kishore Agarwal, 1969, 3 SCC 802, the Supreme Court held that the provision applies equally to legitimate and illegitimate children, emphasizing the child's right to sustenance. 3. Child with physical or mental abnormality. A major child, above 18 years, who is unable to maintain itself due to physical or mental abnormality or injury is also entitled to maintenance. This provision ensures that children with disabilities receive continued support. 4. Parents. The parents of a person, whether father or mother, who are unable to maintain themselves, can claim maintenance from their son or daughter. The Supreme Court in Kirtikant D. Vadodara v. State of Gujarat, 1996, 4 SCC 479 upheld the obligation of children to maintain their aged or infirm parents, reinforcing the cultural and legal duty towards elderly parents. To claim maintenance, the applicant must demonstrate inability to maintain themselves. The respondent has sufficient means but neglects or refuses to provide maintenance. The court assesses the financial capacity of the respondent and the needs of the claimant, ensuring a balance between fairness and practicality. The amount of maintenance is not fixed and varies 22 based on factors such as the respondent's income, the claimant's needs, and the standard of living, as illustrated in Bhagwan Dutt v Kamla Devi, 1975, 2 SCC 386, where the Supreme Court emphasized that maintenance should be sufficient to enable the claimant to live with dignity. Procedure for enforcement of maintenance orders. The enforcement of maintenance orders under Section 125 CRPC is designed to be swift and effective, given the provision's objective of providing immediate relief. The procedure involves the following steps. Filing the application. An application for maintenance is filed before a judicial magistrate of the first class in the district where the applicant or respondent resides, or where the cause of action arose. The application must specify the claimant's relationship with the respondent, their inability to maintain themselves, and the respondent's neglect or refusal to provide maintenance. The application is typically supported by affidavits and documentary evidence, such as proof of marriage, birth certificates, or income details of the respondent. Summary procedure. Section 126 CRPC governs the procedure for maintenance proceedings, which is summary in nature to ensure expeditious disposal. The magistrate issues a notice to the respondent, who must file a reply. The court may record evidence, including oral testimony and documentary proof. The proceedings are not as formal as a full-fledged trial, and the court has discretion to admit evidence to ascertain the truth of the claim. Interim maintenance under Section 125, 1. The court may grant interim maintenance during the pendency of the proceedings to provide immediate relief. The Supreme Court in Savitri Devi v. State of Uttar Pradesh, 1999, 2 SCC 577 emphasized the importance of interim maintenance to prevent hardship to the claimant, particularly in cases of destitution. Order of maintenance. Upon hearing both parties, the magistrate may pass an order directing the respondent to pay a monthly allowance for maintenance, not exceeding the amount claimed. The order specifies the amount, mode of payment, usually monthly, and the date from which it is effective. The maintenance amount can be altered under Section 127 CRPC if there is a change in circumstances, such as an increase in the respondent's income or the claimant's needs. 23. Enforcement of maintenance order. If the respondent fails to comply with the maintenance order, the claimant can seek enforcement under Section 125(3) CRPC. The procedure includes: 1. Application for enforcement. The claimant files an application before the magistrate, stating the respondent's failure to pay the maintenance amount. The application must specify the period of default and the total amount due. 2. Issuance of warrant. If the magistrate is satisfied that the respondent has willfully neglected to comply, a warrant may be issued for levying the amount due by attachment and sale of the respondent's property. In Kuldip Kaur v. Surinder Singh, 1989, 1 SCC 405, the Supreme Court held that the magistrate has wide powers to enforce payment, including attachment of salary or property. 3. Imprisonment for default. If the amount remains unpaid, the magistrate may sentence the respondent to imprisonment for up to 1 month for each month's default, provided the application is made within 1 year from the date the amount became due. The court in Shamima Farooqi v. Shahid Khan, 2015, 5 SCC 705 clarified that imprisonment is a measure of last resort to compel compliance, not a substitute for payment. For recovery through civil process, alternatively, the claimant may approach a civil court to execute the maintenance order as a decree under Section 128 CRPC, allowing recovery through civil remedies like attachment of property or garnishee proceedings. The enforcement process is subject to safeguards to prevent misuse. For instance, the respondent can challenge the maintenance order under Section 127 CRPC if there is a material change in circumstances, such as the claimant's remarriage or improved financial status. Additionally, the court may cancel the order if the claimant is living in adultery or has voluntarily separated without sufficient cause. Landmark case, Shamima Farooqi v. Shahid Khan, 2015, 5 SCC 705. The case of Shamima Farooqi v. Shahid Khan is a landmark judgment that underscores the judicial approach to maintenance under Section 125 CRPC. In this case, the wife sought maintenance for herself and her minor children, alleging neglect by her husband, who was a qualified professional with sufficient means. The trial court granted maintenance, but the husband defaulted on payments, leading to enforcement proceedings. The Supreme Court made several key observations. Maintenance under Section 125 is a measure of social justice to prevent destitution and vagrancy, particularly for women and children. The court emphasized that the husband's obligation to maintain his wife and children persists regardless of personal disputes, provided the claimant meets the eligibility criteria. 24. On enforcement, the court clarified that imprisonment for default is not a substitute for payment but a coercive measure to ensure compliance. The court directed magistrates to prioritize recovery through attachment of property before resorting to imprisonment. The judgment reinforced the secular nature of Section 125, applicable irrespective of personal laws, ensuring uniformity in maintenance rights across communities. This case exemplifies the judiciary's commitment to upholding the welfare objectives of Section 125 while balancing the rights and obligations of both parties. Draft application for maintenance under Section 125 CRPC. Below is a sample application for maintenance under Section 125 CRPC, drafted in a format suitable for filing before a judicial magistrate. The application is for a wife seeking maintenance for herself and her minor child, based on a hypothetical scenario. In the Court of the Judicial Magistrate First Class, City application under Section 125 of the Criminal Procedure Code, 1973 for grant of maintenance in the matter of SMT Anita Sharma, aged 30 years, W/O Shri. Rajesh Sharma, R/O House number 123, Sector 15, City, State. Applicant number 1 and Master Arjun Sharma, aged 5 years, minor son of Shri. Rajesh Sharma, through his mother and natural guardian, SMT Anita Sharma, R/O House number 123, Sector 15, City, State. Applicant number 2 versus Shri. Rajesh Sharma, aged 35 years, S/O Shri. Ramesh Sharma, R/O flat number 456, Sector 20, City, State. Respondent most respectfully showeth, 1 that applicant number 1 is the legally wedded wife of the respondent, having been married to. That applicant number 2 is the minor son of the respondent and applicant number 1, born on 10/3. That the respondent is a software engineer employed with company name, earning amount 4. That since January 2024, the respondent has neglected and refused to maintain the APLI 25/5. That applicant number 1 is unemployed and has no independent source of income to maintain 6. That the applicants are entitled to maintenance under Section 125 CRPC, and the respond prayer, it is, therefore, most respectfully prayed that this honorable court may be pleased to, a. direct the respondent to pay a monthly maintenance of Rs60,000/ to the applicants, i.b., grant interim maintenance of Rs30,000/ per month during the pendency of this applicacy, pass any other order, as this honorable court may deem fit and proper. And for this act of kindness, the applicants shall ever pray. Place, City date, June 15, 2025 SMT Anita Sharma applicant number 1 through advocate name advocate for the applicant's analysis of the draft application. The above application adheres to the requirements of Section 125 CRPC, specifying the relationship between the applicants and the respondent, wife and minor child. The respondent's financial capacity, supported by evidence, salary slips. The applicant's inability to maintain themselves, with reasons for separation, cruelty. A clear prayer for maintenance, including interim relief, to ensure immediate support. The draft is concise yet comprehensive, incorporating legal grounds and factual details to strengthen the claim. It follows the format prescribed under the CRPC and is suitable for filing before a judicial magistrate. 26 Question 6. Defamation under Section 499 IPC and draft complaint under Section 500 IPC. Explain defamation as mentioned under Section 499 Indian Penal Code, 1860. Prepare a draft of complaint for an offence punishable under Section 500 of Indian Penal Code, 1860. Defamation under Section 499 IPC. Section 499 IPC defines defamation as follows: whoever, by words either spoken or written, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm, or knowing, or having reason to believe that such imputation will harm, the reputation of such person, is said, except in the cases hereinafter excepted, to commit the offence of defamation. The offence of defamation comprises the following essential ingredients: 1. Making or publishing an imputation. The accused must make or publish a statement, which can be in the form of spoken words, written text, signs, or visible representations. Publication implies communication to at least one person other than the person defamed. 2. Intention or knowledge of harm. The accused must intend to harm, or know, or have reason to believe that the imputation will harm the reputation of the person concerned. Reputation refers to the collective perception of a person's character or standing in society. 3. Harm to reputation. The imputation must lower the moral or intellectual character of the person, or discredit them in their trade, profession, or calling, or cause them to be shunned or avoided. Defamation under Section 499 can occur in two forms: libel, defamation through written or permanent forms, such as articles, books, or social media posts. Slander, defamation through spoken words or transient forms, such as oral statements or gestures. In India, both libel and slander are criminal offences under Section 499, unlike in some jurisdictions where slander is primarily a civil wrong. The provision applies to imputations against individuals, corporations, or even deceased persons if the imputation harms the reputation of their family or near relatives. Section 499 provides 10 exceptions where an imputation does not constitute defamation. These include: 1. Truth for public good. Exception 1. An imputation that is true and made for the public good is not defamatory. For instance, exposing corruption in public office, if true and in public interest, is protected. 27.2. Public conduct of public servants. Exception 2. Fair criticism of the public conduct of public servants is permissible. 3. Conduct of public figures. Exception 3. Opinions on the conduct of any person touching a public question are not defamatory if expressed in good faith. 4. Publication of court proceedings. Exception 4. Accurate reports of judicial proceedings are protected. 5. Merits of a case or conduct of witnesses. Exception 5. Comments on the merits of a decided case or the conduct of witnesses are permissible if made in good faith. 6. Merits of public performance. Exception 6. Criticism of public performances, such as literary or artistic works, is allowed if in good faith. 7. Censure by authority. Exception 7. Censure passed in good faith by a person in authority is not defamatory. 8. Accusation in good faith. Exception 8. Accusations made to an authorized person in good faith are protected. 9. Imputation for protection of interest. Exception 9. Imputations made to protect one's own or another's interest are permissible if in good faith. 10. Caution for public good. Exception 10. Statements intended to caution others for the public good are not defamatory. The concept of good faith is central to these exceptions, requiring the accused to act with due care and without malice. The Supreme Court in Kaman Lal v. State of Punjab, 1970, 1 SCC 590 emphasized that good faith involves an honest belief in the truth of the statement and absence of malice. Punishment under Section 500 IPC. Section 500 IPC prescribes the punishment for defamation, stating, "Whoever defames another shall be punished with simple imprisonment for a term which may extend to 2 years, or with fine, or with both." The offense is non-cognizable, bailable, and compoundable with the permission of the court. In cases of defamation by spoken words, the offense is non-cognizable unless it incites an offense under Section 505 IPC. The complaint must be filed by the aggrieved person or their authorized representative, as per Section 199 of the Criminal Procedure Code, 1973, CRPC. 28. Landmark case, Subramanian Swamy v. Union of India, 2016, 7 SCC 221. The case of Subramanian Swamy v. Union of India is a seminal judgment that upheld the constitutional validity of Sections 499 and 500 IPC. The petitioners, including Dr. Subramanian Swamy, challenged these provisions, arguing that criminal defamation violates the right to freedom of speech and expression under Article 19, 1a, of the Constitution, as it imposes an unreasonable restriction. The Supreme Court made the following key observations: right to reputation. The court held that reputation is an integral part of the right to life under Article 21, and criminal defamation protects individuals from unwarranted harm to their dignity and standing in society. Reasonable restriction. Criminalizing defamation is a reasonable restriction under Article 19, 2, on the grounds of public order and decency or morality, as false imputations can disrupt social harmony and individual dignity. Balance with free speech. The court acknowledged the importance of free speech but emphasized that it is not absolute. The exceptions under Section 499 provide sufficient safeguards to protect legitimate expressions, such as truth in public interest or fair criticism. Procedural safeguards. The requirement of a complaint by the aggrieved person under Section 199 CRPC ensures that the provision is not misused for frivolous or vexatious litigation. The judgment clarified that criminal defamation serves a public purpose by deterring false and malicious statements, while the exceptions ensure that honest and fair expressions are not penalized. This case remains a cornerstone for understanding the interplay between reputation and free speech in Indian law. Procedure for filing a complaint under Section 500 IPC. To initiate a prosecution for defamation under Section 500 IPC, the following procedural steps are followed under the CRPC. 1. Filing a complaint. The aggrieved person files a private complaint before a magistrate under Section 200 CRPC, detailing the defamatory statement, its publication, and the harm caused to their reputation. The complaint must be accompanied by supporting evidence, such as copies of the defamatory material or witness statements. 2. Preliminary inquiry. The magistrate examines the complainant on oath and may conduct an inquiry to determine if there is a prima facie case. If satisfied, the magistrate issues a process, summons or warrant, against the accused. 3. Trial. The trial follows the procedure for summons cases under Chapter XX of the CRPC. The complainant must prove the ingredients of defamation, while the accused may rely on the exceptions under Section 499. 29. 4. Compounding. The offense is compoundable with the court's permission, allowing the parties to settle the dispute amicably. The complainant bears the burden of proving that the statement was defamatory, published, and caused harm to their reputation, while the accused may plead truth, good faith, or any other exception under Section 499. Draft complaint under Section 500 IPC. Below is a sample complaint for an offense of defamation under Section 500 IPC, based on a hypothetical scenario where a defamatory article was published in a newspaper. The draft is structured to meet the requirements of a criminal complaint under the CRPC in the Court of the Judicial Magistrate First Class, City complaint under Section 200 of the Criminal Procedure Code, 1973 for an offense punishable under Section 500 of the Indian Penal Code, 1860 in the matter of Dr. Anil Verma, aged 45 years, S/O Shri Ramesh Verma, R/O House number 789, Sector 10, City, versus 1. Shri Vikram Singh, Editor, Name of Newspaper, R/O Address of Newspaper Office, 2. Shri Rohan Malhotra, Reporter, Name of Newspaper, R/O Address, City, State. State City, Accused. Complainant state most respectfully showeth, 1. That the complainant is a renowned cardiologist practicing at hospital name, City, 2. That on June 1, 2025, the accused number 1, as editor, and accused number 2, as reporter, PU3. That the said article falsely alleged that the complainant performed negligent surgery. A. Dr. Anil Verma has been negligent in performing critical heart surgeries, leading TB. Sources confirm that Dr. Verma demands exorbitant bribes for providing medical care for. That the above imputations are false, baseless, and made with the intention to harm, or 5. That the article was published to the general public, causing widespread harm to the CO36. That the imputations do not fall under any exception provided under Section 499 IPC, as 7. That the complainant has suffered immense mental agony, loss of professional opportunity. Prayer, it is, therefore, most respectfully prayed that this honorable court may be pleased to, a. Take cognizance of the offense of defamation under Section 500 IPC against the accused. b. Issue process against the accused, summoning them to face trial for the offense. c. Pass any other order, s. as this honorable court may deem fit and proper in the interest of and for this act of kindness, the complainant shall ever pray. Place, City. Date, June 15, 2025. Dr. Anil Verma complainant through advocate. Name advocate for the complainant. Verification, verified at City on this 15th day of June 2025 that the contents of the above complaint Dr. Anil Verma complainant analysis of the draft complaint adheres to the requirements of a criminal complaint under Section 200 CRPC and Section 500 IPC, incorporating details of the complainant and accused, clear identification of the parties involved, specificity of the defamatory statement, precise reproduction of the imputations and their mode of publication, newspaper article. Harm to reputation, evidence of harm through loss of professional opportunities and social standing. Negation of exceptions, assertion that the imputations do not fall under Section 499 exceptions, supported by allegations of malice. Prayer for relief, specific requests for cognizance and issuance of process, aligning with procedural requirements. The draft is concise, legally sound, and structured to facilitate judicial scrutiny, making it a practical example for students of drafting and pleading. 31 Conclusion. Defamation under Section 499 IPC is a robust legal mechanism to protect reputation while balancing the right to free speech through its exceptions. The provision, as upheld in Subramanian Swamy v. Union of India, underscores the importance of reputation as a fundamental right, with criminal sanctions under Section 500 IPC serving as a deterrent against malicious imputations. The draft complaint provided illustrates the practical application of these principles, requiring careful articulation of facts, evidence, and legal grounds. For law students, mastering the drafting of such complaints is essential, as it combines legal theory with the procedural intricacies of criminal law, ensuring effective advocacy in cases of defamation. 32 Question 7. Draft a petition for the writ of habeas corpus. Draft a petition for the writ of habeas corpus. Legal framework for habeas corpus. Constitutional provisions. The writ of habeas corpus is enshrined in Article 32, guarantees the right to move the Supreme Court for enforcement of fundamental rights. Habeas corpus is a direct remedy for unlawful detention violating Article 21, right to life and personal liberty. Article 226, empowers high courts to issue writs, including habeas corpus, for enforcement of fundamental rights or any other purpose, offering wider jurisdiction than Article 32. Statutory provisions. While habeas corpus is primarily a constitutional remedy, it is supported by Section 491, Code of Criminal Procedure, 1898, repealed in 1973 but relevant historically. Criminal Procedure Code, 1973, sections like 97, search for persons wrongfully confined, complement habeas corpus remedies. Judicial precedents. The judiciary has shaped the scope of habeas corpus through landmark rulings. In Sunil Batra v. Delhi Administration, the Supreme Court held that habeas corpus extends beyond mere release to address conditions of detention, such as solitary confinement or torture, violating Article 21. In ADM Jabalpur v. Shivkant Shukla, 1976, the scope was temporarily restricted during the emergency, but post-emergency, courts reaffirmed its inviolability. Principles of drafting a habeas corpus petition. Drafting a habeas corpus petition requires precision, adherence to court rules, and a focus on the violation of personal liberty. The following principles guide effective drafting: clarity and conciseness. The petition must clearly state the facts of detention, the authority responsible, and the alleged illegality. Order 6, Rule 2 of the Code of Civil Procedure, 1908, CPC, though not directly applicable, emphasizes concise material facts in pleadings. 33 Material facts. The petition must include details of the detained person, detenu, circumstances and date of detention, authority or person responsible for detention, grounds for alleging illegality, e.g., violation of statutory procedure or fundamental rights. No legal arguments. The petition should focus on facts, leaving legal arguments to be presented during hearings, aligning with CPC principles. Order 6, Rule 2. Urgency and expedition. Given the urgency of habeas corpus, the petition must highlight the need for immediate relief. Courts prioritize such petitions, often hearing them within 24-48 hours. Affidavit support. The petition must be accompanied by an affidavit verifying the facts, sworn by the petitioner or someone with personal knowledge, e.g., a relative of the detainee. Jurisdiction and relief. The petition must specify whether it is filed under Article 32 or Article 226 and clearly state the relief sought, typically the production and release of the detainee. Relevance of Sunil Batra v. Delhi Administration. In Sunil Batra v. Delhi Administration, 1978, the Supreme Court expanded the scope of habeas corpus, holding that it is not limited to securing physical release but can address unlawful conditions of detention. The case involved a prisoner subjected to solitary confinement, which the court deemed a violation of Article 21. Facts of the case. Sunil Batra, a convict, challenged his solitary confinement in Tihar jail, alleging it was arbitrary and inhumane. The petition was filed under Article 32, seeking relief against prison authorities. 34 Legal principles established. Habeas corpus extends to protecting prisoners from inhumane treatment, ensuring dignity under Article 21. Courts can issue directions to improve prison conditions, even without ordering release. Public interest. Habeas corpus is permissible, allowing third parties, e.g., activists, to file petitions on behalf of detainees. Implications for drafting. The Sunil Batra case emphasizes, including details of detention conditions if they violate fundamental rights. Allowing petitions by third parties if the detainee cannot approach the court. Drafting prayers for both release and ancillary relief, e.g., improved conditions. Essential components of a habeas corpus petition. A habeas corpus petition must include 1. Heading and title, name of the court, case number, and parties, petitioner versus respondents. 2. Petitioner's details, name, address, and relationship to the detainee. 3. Respondents' details, authorities or individuals responsible for detention, e.g., police, jail superintendent. 4. Facts of detention, date, place, circumstances, and alleged illegality. 5. Grounds for relief, specific violations, e.g., lack of legal authority, procedural lapses. 6. Prayer for relief, request for production and release of the detainee. 7. Affidavit, sworn statement verifying facts. 8. Annexures, supporting documents, e.g., arrest warrant, news reports. Sample habeas corpus petition. Below is a sample petition filed under Article 226 before the Delhi High Court, illustrating the principles discussed. 35. In the High Court of Delhi at New Delhi. Writ petition, criminal, no. ___ of 2025, under Article 226 of the Constitution of India, in the matter of Mrs. Priya Sharma, W/O Mr. Anil Sharma, R/O123, Green Park, New Delhi 110016. Petitioner vs1. The State of NCT of Delhi, through the Home Secretary, Secretariat, New Delhi 110012. The Commissioner of Police, Delhi Police Headquarters, New Delhi 110013. The Superintendent, Tihar Jail, New Delhi 110064. Respondent's petition for writ of habeas corpus to the Honorable Chief Justice and his companion justices of the Honorable High Court of Delhi. Most respectfully shouth. 1. The petitioner is the wife of Mr. Anil Sharma, hereinafter detainee, aged 40 years, Re 2. The detainee was arrested by the Delhi police on June 10, 2025, at 8 p.m. from his rest 3. The detainee is detained at Tihar Jail, New Delhi, under the custody of respondent number 3. 4. The petitioner was informed by neighbors that the arrest was related to an alleged theft. 5. The respondents have failed to produce the detainee before a magistrate within 24 hours. 6. The detention is illegal and violates the detainee's fundamental right to personal liberty. 7. The petitioner has not approached any other court for this relief. Grounds. A. The arrest was made without a warrant or disclosure of grounds, violating Article 22, 1, B. Failure to produce the detenue before a magistrate within 24 hours contravenes Article 2c. The detention is arbitrary, lacking legal authority, and violates Article 21. D. The conditions of detention, including denial of access to legal counsel, are inhumane. Prayer, the petitioner prays that this honorable court may be pleased to, 36a, issue a writ of habeas corpus directing the respondents to produce the detenue before THB, order the immediate release of the detenue. C. Direct the respondents to provide humane treatment to the detenue pending hearing. D. Award costs of the petition. E. Pass such other orders as deemed fit. Verification, verified at New Delhi on this 15th day of June, 2025, that the contents of the above petty signature Mrs. Priya Sharma petitioner affidavit I, Priya Sharma, W/O Anil Sharma, aged 38 years, R/O123, Green Park, New Delhi 110016, do 1. I am the petitioner and am conversant with the facts of the case. 2. The contents of the petition are true to my knowledge. 3. No part of the petition is false, and nothing material has been concealed. Deponent signature verified at New Delhi on June 15, 2025. Analysis of the sample petition. The sample petition incorporates jurisdiction, filed under Article 226, specifying the Delhi High Court. Facts, details of the arrest, detention, and alleged illegality. Grounds, references to constitutional and statutory violations, citing Sunil Batra. Prayer, specific relief for production, release, and humane treatment. Affidavit, verification of facts, ensuring procedural compliance. Practical considerations. Common mistakes to avoid: omitting material facts, failing to specify the date or place of detention weakens the petition. Lack of affidavit, an unverified petition may be dismissed. Incorrect respondents, naming irrelevant authorities delays relief. 37. Filing procedure. File with the court registry, accompanied by court fees. Serve copies to respondents. Ensure urgency is highlighted for expedited hearing. Examination tips. Structure, begin with the legal framework, Articles 32, 226, followed by principles and a sample petition. Cite case law, reference Sunil Batra to show expanded scope. Include affidavit, demonstrate procedural awareness. 38. Question 8, draft a public interest litigation related to environmental issue. Draft a public interest litigation related to environmental issue. Legal framework for environmental pills. Environmental pills are grounded in constitutional and statutory provisions, including, Article 21, guarantees the right to life, interpreted to include the right to a pollution-free environment. Article 32, empowers the Supreme Court to issue writs for enforcement of fundamental rights. Article 226, grants High Courts similar powers within their jurisdiction. Article 48a, directs the state to protect and improve the environment, directive principles of state policy. Article 51a, G imposes a fundamental duty on citizens to protect the environment. Environment Protection Act, 1986, provides a framework for pollution control and environmental conservation. Water Prevention and Control of Pollution Act, 1974, regulates water pollution by industries and municipalities. Public Liability Insurance Act, 1991, ensures compensation for victims of environmental accidents. Judicial precedents, such as MC Mehta v Union of India, Ganga pollution case, have established principles like the polluter pays and precautionary principles, which guide environmental pills. Drafting a public interest litigation. Model petition below is a model pill drafted to address the issue of illegal industrial pollution in a fictional river, the Surya River, causing environmental and public health harm. The draft complies with the procedural requirements of the Supreme Court Rules, 2013, and incorporates elements from leading cases. In the Supreme Court of India, Civil Original Jurisdiction, Writ Petition, Civil, No. ____ of 2025, under Article 32 of the Constitution of India, in the matter of petitioner's name, Public Spirited Citizen 39 Resident of Address, New Delhi, Petitioner vs. 1. Union of India, through the Secretary, Ministry of Environment, Forest and Climate Change 2. State of State, through the Chief Secretary 3. State Pollution Control Board 4. XYZ Industries Limited, Registered Office Address, Respondents Public Interest Litigation under Article 32 seeking directions to prevent illegal industrial pollution in the Surya River 2. The Honourable Chief Justice of India and his companion Justices of the Honourable Supreme Court of India most respectfully showeth, 1. That the petitioner, a public-spirited citizen and environmental activist, files this P2. That the Surya River, a vital water source for drinking, irrigation, and aquatic ecosystems 3. That the respondents number 1 to 3 have failed to enforce environmental laws, allowing UNCA, contamination of drinking water, causing health issues like list diseases. B. Loss of aquatic biodiversity, as evidenced by reports/studies. C. Adverse impact on agriculture dependent on the river. 4. That the petitioner has no personal interest in this matter and files this PIL in the PA, Water Quality Reports by independent agency. B. News articles highlighting the pollution crisis. C. Representations made to respondent number 3, which remain unaddressed. 5. That this Honourable Court, in /text EMC Made of the Union of India, 1987, Air 1987 SC 10-6. That the inaction of the respondents violates Articles 21, 48A, and 51A, G, of the Const Prayer. In view of the above facts and circumstances, it is most respectfully prayed that this Hon A. issue a writ of mandamus directing respondent number 3 to immediately inspect and close in B, direct respondent number 4 to pay compensation for environmental damage under the Pollute C, constitute a high-powered committee to monitor and restore the Surya River. D. Pass any other orders as this Honourable Court deems fit in the interest of justice. 40 Place, New Delhi. Date Advocate for the petitioner Annex Yours, Annexure P1, Water Quality Report dated date. Annexure P2, News articles dated dates. Annexure P3, Copy of Representation to Respondent number 3 dated date. Affidavit I, Petitioner's name, aged age, resident of address, do hereby solemnly affirm and D1. That I am the petitioner in the above writ petition and am fully conversant with the FA2. That the contents of the writ petition are true to my knowledge and based on authentic 3. That no part of this affidavit is false, and nothing material has been concealed. Deponent verification, verified at New Delhi on date that the contents are true. Essential elements of appeal drafting appeal requires incorporating specific elements to ensure procedural and substantive compliance. 1. Cause, title and jurisdiction. The petition must clearly state the court, Supreme Court or High Court, and the parties, including the petitioner and respondents, government authorities and private entities. 2. Public interest declaration. The petitioner must affirm that the PIL is filed in the public interest, without personal gain, as emphasized in State of Uttaranchal v. Balwant Singh Shofal, 2010, 3 SCC 402. 3. Facts and grounds. The petition must detail the environmental issue, supported by evidence, e.g., reports, studies, and cite legal provisions, constitutional and statutory, violated by the respondents. 4. Prayer for relief. The relief sought must be specific, such as writs of mandamus, prohibition, or directions for compensation and restoration. 5. Affidavit. An affidavit verifying the facts must accompany the petition, as per Order 19 of the Code of Civil Procedure, 1908, CPC. 6. Annexures. Supporting documents, such as scientific reports, news articles, or prior representations, must be annexed and indexed. 41.7. Court fee and format. The petition must comply with court rules, including payment of court fees under the Court Fees Act, 1870, and formatting per the Supreme Court Rules, 2013. Landmark case law analysis. Environmental pills have shaped India's environmental jurisprudence, with the following cases providing guidance for drafting: M.C. Mehta v. Union of India, 1987, Air 1987 SC 1086, Ganga pollution case. This seminal case addressed pollution of the Ganga River by tanneries in Kanpur. The Supreme Court, acting on appeal filed by M.C. Mehta, directed the closure of polluting industries, mandated the installation of effluent treatment plants, and introduced the polluter pays principle. The court held that the right to a clean environment is part of Article 21, setting a precedent for environmental pills. Drafting a pill for river pollution, as in the model above, must cite this case to invoke judicial powers for immediate remedial action. Vellore Citizens Welfare Forum v. Union of India, 1996, 5 SCC 647. In this case, the Supreme Court addressed pollution by tanneries in Tamil Nadu, affecting rivers and groundwater. The court endorsed the precautionary principle and sustainable development, directing the establishment of a monitoring committee and compensation for affected communities. This case guides the inclusion of prayers for monitoring mechanisms and compensation in environmental pills. Drafting considerations and challenges. Drafting an environmental pill involves several considerations and challenges. Locus standi, the petitioner must establish their public-spirited intent, avoiding frivolous or motivated litigation, as cautioned in Balwant Singh Shofal, 2010. Evidentiary support, scientific evidence, such as water quality reports or health studies, strengthens the petition. Lack of credible evidence may lead to dismissal. Clarity in reliefs. Prayers must be specific and actionable, avoiding vague requests like protect the environment. Balancing interests. The petition must address the economic impact on industries while prioritizing environmental protection, as seen in Indian Council for Enviro-Legal Action v. Union of India, 1996, 3 SCC 212. Procedural compliance. Non-compliance with court rules, such as improper indexing or missing affidavits, may result in rejection. 42 Strategic tips for effective drafting. To draft a compelling environmental pill, use concise and persuasive language, avoiding legal jargon where possible. Structure the petition logically, with numbered paragraphs for clarity. Cite relevant case law to strengthen legal arguments, e.g., M.C. Mehta for pollution control measures. Include a prayer for a monitoring committee to ensure compliance with court orders, as seen in Vellore Citizens Welfare Forum. Anticipate defenses, such as claims of economic hardship by industries, and counter them with the polluter pays principle. 43 Question 9. Draft a sale deed. Draft a sale deed on behalf of an owner of the house. Principles of drafting a sale deed. Definition and legal framework. A sale deed is a legal instrument that evidences the transfer of ownership of immovable property. According to Section 54 of the TPA, a sale of immovable property valued above Rs 100 must be made through a registered instrument. The sale deed serves as the primary evidence of the transaction and must comply with the Indian Registration Act, 1908, and the Indian Stamp Act, 1899, to be legally valid. Essential elements of a sale deed. A well-drafted sale deed must include the following components: title, clearly stating that the document is a sale deed. Parties, full details of the seller, vendor, and buyer, purchaser, including names, addresses, and identification details. Recitals, background information, including the seller's title and agreement to sell. Consideration, the price agreed upon for the property. Description of property, a detailed schedule of the property, including boundaries, measurements, and any encumbrances. Terms and conditions, rights, obligations, and covenants of the parties. Execution and attestation, signatures of the parties and at least 2 witnesses, along with registration details. Statutory requirements. Registration, under Section 17 of the Indian Registration Act, 1908, a sale deed for immovable property must be registered at the appropriate sub-registrar's office. Stamp duty, the deed must be executed on stamp paper of appropriate value as per the Indian Stamp Act, 1899, varying by state. Clarity and precision, the language must be clear, avoiding ambiguity to prevent disputes. 44 Relevance of Sarai Lamp and Industries Private Limited v State of Haryana. The Supreme Court case Sarai Lamp and Industries Private Limited v State of Haryana, 2012, is a pivotal judgment in the context of conveyancing in India. The case addressed the validity of property transfers through unregistered documents, such as General Power of Attorney, GPA, agreements to sell, or wills, which were being misused to evade stamp duty and registration requirements. Facts of the case: the case involved transactions where immovable property was transferred using unregistered documents, leading to disputes over title. The Supreme Court examined whether such practices complied with the TPA and the Indian Registration Act. Legal principle established: the court held that only a registered sale deed can validly transfer title to immovable property. Unregistered documents, even if notarized, do not confer legal title and are merely collateral agreements. The judgment emphasized the mandatory requirement of registration under Section 17(1)(b) of the Indian Registration Act, 1908. The importance of paying appropriate stamp duty to prevent revenue loss to the state. The need to curb fraudulent practices that undermine the legal framework for property transfers. Implications for drafting. The Sarai Lamp case underscores the importance of meticulous drafting and adherence to statutory requirements. A sale deed must be registered to ensure legal validity. Drafted with clear recitals to establish the seller's title. Executed on appropriate stamp paper to comply with fiscal laws. Practical considerations in drafting a sale deed: verification of title. Before drafting, the lawyer must verify the seller's title through title deeds and chain of ownership. Encumbrance certificates for the last 13 years. Revenue records, such as CATA certificates and mutation entries. 45 Clarity in property description. The schedule of the property must be precise, including exact location and boundaries, measurements and survey numbers, any fixtures or appurtenances included in the sale. Terms and covenants. The deed should include covenants such as the seller's warranty of clear title, the buyer's obligation to pay consideration, indemnity clauses for future disputes. Local laws and practices. State-specific laws, such as stamp duty rates and registration procedures, must be adhered to. For example, in Karnataka, the Karnataka Stamp Act, 1957, governs stamp duty, while in Maharashtra, the Maharashtra Stamp Act, 1958, applies. Sample sale deed. Below is a sample sale deed drafted on behalf of the owner of a house, incorporating the principles discussed and ensuring compliance with Indian laws. The deed is fictional but reflects standard practice. Drafting the sale deed. Sale deed. The sale deed is made and executed on this 15th day of June, 2025, at Bangalore, Karnataka. Mr. Anil Kumar Sharma, son of Mr. Ramesh Sharma, aged 45 years, residing at number 123, First M, and Mrs. Priya Venkatesh, wife of Mr. Suresh Venkatesh, aged 38 years, residing at number 456, 2 and whereas, A. The vendor is the absolute owner of the immovable property, being a residential house. B. The vendor acquired the schedule property by the registered sale deed dated March 10. C. The vendor has agreed to sell, and the purchaser has agreed to purchase, the Schedule P46D. The vendor has delivered to the purchaser all relevant title documents, and the purchase. Now this deed witnesseth as follows: 1. In consideration of the sum of Rs 1,50,00,000 rupees 1 crore 50 lakhs only, P2. The vendor hereby covenants with the purchaser that, A. The vendor has good, marketable, and absolute title to the schedule property. B. The schedule property is free from all encumbrances, charges, liens, or litigation. C. The vendor shall indemnify the purchaser against any claims or disputes arising from 3. The purchaser shall henceforth enjoy quiet possession of the scheduled property without 4. The vendor has handed over all original title documents and possession of the Schedule 5. The stamp duty and registration charges have been borne by the purchaser as per the car schedule of property. All that piece and parcel of residential property bearing house number 789, situated at 3rd M, East, house number 788, West, 3rd Main Road, North, house number 790, South, open plot together with all structures, fittings, fixtures, and appurtenances thereto. In witness whereof, the parties hereto have set their hands and signatures on the day and signed and delivered by, vendor, Mr. Anilkumar Sharma signature, purchaser, Mrs. Priya Venkatesh signature. Witnesses, 1 Mr. Rajesh Kumar, number 456, 4th Main, HSR Layout, Bangalore, 560,102 signature 2. Ms. Anitha Rao, number 789, 5th Cross, Koramangala, Bangalore, 560,034 signature %. End of sale deed. Analysis of the sample sale deed. The sample sale deed incorporates the following key features: 47 identification of parties, full details of the vendor and purchaser, including addresses and relationships, ensure clarity. Recitals. The recitals establish the vendor's title and the agreement to sell, providing a legal foundation. Consideration. The exact amount is stated in both figures and words to avoid ambiguity. Schedule of property. The detailed description, including boundaries and measurements, complies with conveyancing standards. Covenants. The vendor's warranties and indemnity clauses protect the purchaser's interests. Execution. Signatures of the parties and witnesses, along with registration details, fulfill statutory requirements. Legal and practical tips for students. Common mistakes to avoid: omitting essential clauses, such as covenants or property descriptions. Failing to verify the vendor's title, leading to disputes. Incorrect calculation of stamp duty, resulting in legal invalidity. Examination tips when answering questions on drafting a sale deed. Begin with a brief explanation of the legal framework, TPA, Registration Act, Stamp Act. Provide a structured sale deed with clear headings and clauses. Reference relevant case law, such as Sarai Lamp, to demonstrate depth. Ensure the language is formal and precise, avoiding vague terms. 48. Question 10. Drafting, partnership deed, gift deed, lease deed. Attempt any two from the following: A. Draft a partnership deed. B. Draft a gift deed of immovable property. C. Draft a lease deed. Partnership deed. A partnership deed is a written agreement that outlines the terms and conditions governing a partnership under the Indian Partnership Act, 1932. Section 4 of the Act defines a partnership as the relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. The deed serves as evidence of the partnership and helps prevent disputes by clearly defining roles, capital contributions, profit-sharing ratios, and other terms. In Commissioner of Income Tax v. Dewasina Corporation, Air 1968 SC 676, the Supreme Court emphasized that a partnership deed must reflect a mutual agreement to share profits and losses, reinforcing its contractual nature. Sample partnership deed. Partnership deed. This partnership deed is executed on this 15th day of June, 2025, at Delhi, India, between 1 Mr. Vikram Sharma, son of Mr. Anil Sharma, aged 35 years, resident of 123, Vasant Vihar, Delhi 110,057, hereinafter referred to as the first party. 2 Ms. Priya Gupta, daughter of Mr. Rajesh Gupta, aged 32 years, resident of 456, Saket, Delhi 110,017, hereinafter referred to as the second party. Whereas the parties desire to carry on a business in partnership under the terms and conditions hereinafter set forth, now this deed witnesseth as follows: Name and nature of business. The partnership shall be carried on under the name and style of BP Enterprises and shall engage in the business of software development and IT consultancy at 789, Nehru Place, Delhi 110,019, or at such other place as the partners may mutually decide. Duration: the partnership shall commence on June 15, 2025, and shall continue until dissolved by mutual consent or as per the provisions of the Indian Partnership Act, 1932. 49. Capital contribution: the first party shall contribute Rs 10,00,000, rupees 10 lakhs, in cash. The second party shall contribute Rs 8,00,000, rupees 8 lakhs, in cash. Additional capital, if required, shall be contributed in the ratio of 5:4, unless otherwise agreed. Profit and loss sharing: the profits and losses of the partnership shall be shared between the partners in the ratio of their capital contribution, i.e., 5:4, first party, second party, as upheld in Commissioner of Income Tax v. D. Wasina Corporation, Air 1968 SC 676. Management: both partners shall actively participate in the management of the business. Major decisions, including borrowing funds, acquiring assets, or entering contracts exceeding Rs 5,00,000, shall require mutual consent. Books of account: the partnership shall maintain proper books of account, which shall be accessible to both partners at all reasonable times. The accounts shall be audited annually by a chartered accountant. Interest on capital: no interest shall be payable on the capital contributed by the partners unless mutually agreed upon in writing. Salary or remuneration: the second party shall be entitled to a monthly remuneration of Rs 50,000 for managing daily operations, subject to adjustment based on profits. Banking: the partnership shall maintain a bank account with name of bank, Nehru Place Branch, Delhi. All transactions shall be conducted through this account, and both partners shall be authorized signatories. Admission and retirement: no new partner shall be admitted without the consent of both parties. A partner wishing to retire shall give 6 months written notice and settle accounts as per Section 48 of the Indian Partnership Act, 1932. 50. Dissolution: the partnership may be dissolved by mutual consent or as per the provisions of the Indian Partnership Act, 1932. Upon dissolution, assets shall be distributed after settling liabilities, in accordance with the partners' capital contribution ratio. Dispute resolution: any dispute arising out of this deed shall be resolved through arbitration in Delhi, as per the Arbitration and Conciliation Act, 1996, with a sole arbitrator appointed by mutual consent. In witness whereof, the parties hereto have set their hands on the day and year first above written. Signed and delivered by Mr. Vikram Sharma, Ms. Priya Gupta. Signature in the presence of witnesses, of witness 1, address, witness address, signature, of witness 2, address, witness address, signature. Gift deed of immovable property: a gift deed is a legal document that facilitates the voluntary transfer of immovable property without consideration, as governed by Section 122 of the Transfer of Property Act, 1882. Section 122 defines a gift as the transfer of certain existing movable or immovable property made voluntarily and without consideration, by one person, called the donor, to another, called the donee, and accepted by or on behalf of the donee. The deed must be executed, attested, and registered under Section 123 of the Act to be valid. In Kokla Devi v. Chetram, Air 2002 SC 1730, the Supreme Court held that a gift deed must clearly demonstrate the donor's intention to transfer ownership and the donee's acceptance to be legally enforceable. Sample gift deed of immovable property: this gift deed is executed on this 15th day of June, 2025, at Delhi, India, by Mr. Anil Kumar, son of Mr. Ramesh Kumar, aged 60 years, resident of 123, Greater Kailash, Delhi 110,048, hereinafter referred to as the donor, in favor of Ms. Shalini Kumar, daughter of Mr. Anil Kumar, aged 30 years, resident of 456, Vasant Kunj, Delhi 110,070, hereinafter referred to as the donee. Whereas, 51(1). The donor is the absolute owner of the immovable property described in the schedule below, acquired vide sale deed dated January 10, 2000, registered at the Sub-Registrar's Office, Delhi. 2. The donor desires to gift the said property to the donee out of natural love and affection, without any consideration, as per Section 122 of the Transfer of Property Act, 1882. 3. The donee has agreed to accept the gift, as required under Kokla Devi v Chetram, Air 2002 SC 1730. Now this deed witnesseth, transfer of property. The donor hereby transfers, conveys, and assigns all rights, title, and interest in the immovable property described in the schedule below to the donee, absolutely and forever, without any consideration. Description of property, schedule, nature, residential plot location, plot number 789, Greater Kailash, Part 2, Delhi 110,048 area, 500 square yards. Boundaries, North Plot No 788, South Plot No 790, East Main Road, West Plot number 787. Details, freehold property, free from encumbrances, as per title documents. Acceptance. The donee hereby accepts the gift of the said property and takes possession thereof on the date of execution of this deed. No encumbrances. The donor declares that the property is free from all liens, charges, and encumbrances, and the donor has full authority to gift the same. Registration. This deed shall be registered with the Sub-Registrar, Delhi, as required under Section 123 of the Transfer of Property Act, 1882, and Section 17 of the Indian Registration Act, 1908. 52. Revocation. The gift is absolute and irrevocable, as per the provisions of the Transfer of Property Act, 1882, and the donor retains no right to revoke the same. In witness whereof, the donor and donee have set their hands on the day and year first above written. Signed and delivered by Mr. Anil Kumar, donor, Ms. Shalini Kumar, donee. Signature in the presence of witnesses, of witness 1, address, witness address, signature, of witness 2, address, witness address, signature. Legal principles in drafting. Drafting a partnership deed and a gift deed requires adherence to specific legal principles to ensure validity and enforceability. Partnership deed. Clarity and specificity. The deed must clearly define the partnership's terms, including capital, profit sharing, and management, as emphasized in Commissioner of Income Tax v. Dewasina Corporation, Air 1968 SC 676. Compliance with statute. The deed must comply with the Indian Partnership Act, 1932, particularly Sections 4, 11, and 48, governing partnership formation, mutual rights, and dissolution. Witnesses and execution. The deed should be executed in the presence of witnesses and, though not mandatory, may be registered under Section 59 of the Act for evidentiary value. Gift deed. Voluntary intent and acceptance. The deed must reflect the donor's voluntary intent and the donee's acceptance, as held in Kokla Devi v Chetram, Air 2002 SC 1730. Registration and attestation. Under Section 123 of the Transfer of Property Act, 1882, the deed must be attested by at least 2 witnesses and registered to be valid. Clear description. The property must be described in detail, including boundaries and title status, to avoid ambiguity. 53. Question 11. Understanding revision and grounds for revision. What do you understand by revision? On what grounds a revision can be made? Understanding revision under the CRPC. Revision under the CRPC is a discretionary power vested in the High Court and Sessions Court to call for and examine the records of any proceeding before an inferior criminal court within their jurisdiction. Section 397, 1. CRPC empowers these courts to ensure that the subordinate court's proceedings are conducted in accordance with the law. The primary objectives of revision are, to correct errors of jurisdiction, law, or procedure, to prevent miscarriage of justice, to ensure fairness and adherence to legal principles in judicial proceedings. Revision differs from an appeal in several key aspects. 1. Scope. An appeal involves a comprehensive re-examination of facts and law, whereas revision is limited to examining the legality, propriety, or correctness of the subordinate court's order or proceeding. 2. Initiation. An appeal is a statutory right available to parties, while revision can be initiated suo motu by the court or on an application by an aggrieved party or even a third party. 3. Fact-finding. Revisional courts generally do not re-evaluate evidence or findings of fact unless there is a gross error or perversity. In contrast, appellate courts may reassess factual findings. 4. Powers. Under Section 401 CRPC, the revisional court has wide powers, including staying proceedings, altering or reversing orders, or directing further inquiry, but it cannot convert a finding of acquittal into conviction. Section 401, 3. The key provisions governing revision are, Section 397 CRPC, empowers the High Court or Sessions Court to call for records of any proceeding to satisfy itself as to the correctness, legality, or propriety of any finding, sentence, or order. Section 399 CRPC, specifies the powers of the Sessions Court in revision, which are akin to those of the High Court, subject to certain limitations. Section 401 CRPC, grants the High Court broad revisional powers, including the ability to exercise powers of an appellate court, but prohibits converting an acquittal into a conviction. Section 402 CRPC, allows the High Court to withdraw a revision case pending before a Sessions Court for its own disposal. 54 Revision can be invoked against interlocutory orders, final orders, or findings, provided they are not purely interlocutory in nature, as barred by Section 397, 2, CRPC. The Supreme Court in Madan Lal v. State of Punjab, 1967, 3 SCR 439 clarified that an interlocutory order is one that does not finally determine the rights of the parties, such as orders on bail or framing of charges. Grounds for revision. Revision is not a substitute for an appeal but a mechanism to address specific errors in the judicial process. The grounds for revision, as established through judicial pronouncements, include 1. Jurisdictional error. If the subordinate court acts without jurisdiction or exceeds its jurisdiction, revision can be sought. For instance, a magistrate passing a sentence beyond their statutory limit is a revisional ground. 2. Illegality or incorrectness. An order that is manifestly illegal or contrary to law warrants revision. This includes misinterpretation of statutory provisions or failure to apply binding precedents. 3. Procedural irregularity. Any irregularity in the procedure that affects the fairness of the trial, such as denial of the right to be heard or failure to record evidence properly, is a valid ground. In Akbar Ali v. State of Uttar Pradesh, 1999, 6 SCC 314, the Supreme Court held that procedural lapses causing prejudice to a party justify revisional intervention. 4. Perversity in findings. Findings of fact that are perverse, arbitrary, or not supported by evidence can be challenged. A perverse finding is one that no reasonable person could arrive at based on the evidence, as noted in K. Chinnaswamy Reddy v. State of Andhra Pradesh, 1962, 3 SCR 412. 5. Impropriety of order. An order that is unjust or improper, even if not illegal, may be revised if it results in a miscarriage of justice. This includes disproportionate sentences or orders passed without considering material evidence. 6. Non-application of mind. If the court fails to apply its judicial mind, such as passing an order mechanically or ignoring relevant material, revision is maintainable. 7. Violation of natural justice. Denial of principles of natural justice, such as audi alteram partem, right to be heard, is a ground for revision. For example, passing an order without giving the accused an opportunity to present their case is revisable. The revisional court cannot convert an acquittal into a conviction, Section 401, 3, CRPC. Reappreciate evidence unless there is a gross error or perversity. Interfere with interlocutory orders, such as bail or charge framing orders, unless they cause grave injustice, Section 397, 2. 55. The Supreme Court in State of Kerala v. Puttumana Elate Jathav Nambudiri, 1999, 2 SCC 452 emphasized that revisional jurisdiction is supervisory and not meant to substitute the lower court's discretion unless there is a clear error of law or fact. Landmark case, Pranav Kumar Mishra v. State of Uttar Pradesh, 2008, 16 SCC 318. The case of Pranav Kumar Mishra v. State of Uttar Pradesh is a seminal judgment that clarifies the scope and limitations of revisional jurisdiction under the CRPC. In this case, the petitioner sought revision of an order passed by a magistrate dismissing a complaint under Section 203 CRPC. The petitioner argued that the magistrate's order was perverse and failed to consider material evidence. The Supreme Court made the following observations: limited scope of revision. The revisional court should not act as an appellate court by re-evaluating evidence unless there is a manifest error or perversity in the lower court's findings. Perversity defined: a finding is perverse if it is based on no evidence, contrary to evidence, or so unreasonable that no prudent person could arrive at it. Discretionary power: revisional jurisdiction is discretionary, and the court may decline to interfere if the error does not result in a miscarriage of justice. Procedural fairness: the magistrate's failure to consider material evidence or provide reasons for dismissal warranted revisional intervention, as it violated procedural fairness. The court set aside the magistrate's order and directed further inquiry, underscoring the revisional court's role in correcting errors that affect justice. This case is a guiding precedent for drafting revision applications, emphasizing the need to highlight specific errors of law, fact, or procedure. Procedure for filing a revision: the procedure for filing a revision under the CRPC involves the following steps. 1. Filing the application. A revision petition is filed before the High Court or Sessions Court, specifying the impugned order, the grounds for revision, and the relief sought. The petition must be accompanied by certified copies of the lower court's order and relevant records. 2. Limitation period. While the CRPC does not prescribe a specific limitation period for revision, courts expect applications to be filed within a reasonable time, typically 90 days, as per the Limitation Act, 1963. 3. Hearing. The revisional court examines the records and may hear the petitioner and the opposite party. It may also call for additional evidence or direct further inquiry under Section 398 CRPC 4. Orders in revision. The court may dismiss the petition, alter or reverse the order, or direct a retrial or further inquiry. The decision must be reasoned and based on the record. 56. The revisional court has wide powers under Section 401 CRPC, including staying proceedings, granting interim relief, or referring the case to another court. Draft revision application below is a sample revision application filed before a sessions court, challenging a magistrate's order on the ground of procedural irregularity and perversity. The draft is based on a hypothetical scenario involving a conviction under Section 138 of the Negotiable Instruments Act, 1881. In the court of the sessions judge, city criminal revision petition under Section 397 read with Section 401 of the Criminal Procedure in the matter of Shri Vikram Singh, aged 40 years, S/O Shri Ramesh Singh, R/O House number 456, Sector 12, City, State. Petitioner vs. 1. State of State, through the Public Prosecutor 2. Shri Anil Sharma, aged 45 years, S/O Shri Mohan Sharma, R/O flat number 789, Sector 15, City, State. Respondents most respectfully Shawith, 1. That the petitioner was convicted by the learned judicial magistrate first class, City 2. That the petitioner is aggrieved by the said order on the following grounds: a. Text procedural irregularity, the learned magistrate failed to provide the petty. B. Text perversity in findings, the finding of guilt is perverse, as the magistrate. C. Text non-application of mind, the magistrate mechanically relied on the complaint. D. Text disproportionate sentence, the sentence of 6 months imprisonment is DISP 3. That the impugned order has resulted in a miscarriage of justice, causing grave prejudice. 4. That the petitioner has not filed any other revision or appeal against the impugned order. It is, therefore, most respectfully prayed that this honorable court may be pleased to a. Call for the records of criminal case No. 123/2024 from the Court of the Judicial Magus. B. Set aside the impugned order dated April 15, 2025 and acquit the petitioner of the charge. C. In the alternative, direct a retrial or further inquiry into the matter. D. Grant interim stay of the impugned order pending disposal of this revision petition. E. Pass any other order, s. as this honorable court may deem fit and proper in the interest of 57 and for this act of kindness, the petitioner shall ever pray. Place, City. Date, June 15, 2025. Shri Vikram Singh petitioner through advocate name advocate for the petitioner verification, verified at City on this 15th day of June 2025 that the contents of the above petition A. Shri Vikram Singh petitioner analysis of the draft application. The draft revision application adheres to the requirements of a criminal revision petition under the CRPC, incorporating details of the impugned order, clear identification of the order being challenged, with a certified copy annexed. Specific grounds: articulation of procedural irregularity, perversity, and disproportionality, supported by legal provisions and evidence. Prayer for relief: specific requests for setting aside the order, retrial, or interim stay, aligning with the powers under Section 401 CRPC. Verification: a formal verification clause to affirm the truthfulness of the petition. The draft is concise, legally precise, and structured to facilitate judicial review, making it a practical example for students of drafting and pleading. 58. Question 12. Meaning and objectives of affidavit. Discuss the meaning and objectives of the affidavit. Meaning of an affidavit. An affidavit is a voluntary written declaration of facts, made under oath or affirmation, before a person authorized to administer oaths, such as a notary public, magistrate, or oath commissioner. Derived from the Latin term affidere, meaning to pledge, an affidavit is a solemn promise to tell the truth, carrying legal consequences for falsehood, including penalties for perjury under Section 191 of the Indian Penal Code, 1860, IPC. The affidavit serves as a substitute for oral testimony in certain proceedings, allowing parties to present facts in a structured and verifiable format. In India, affidavits are governed by Code of Civil Procedure, 1908, CPC Order 19 of the CPC regulates affidavits in civil proceedings, specifying their form, content, and use as evidence. Section 30, C, CPC empowers courts to order affidavits for proof of facts. Criminal Procedure Code, 1973, CRPC affidavits are used in criminal proceedings for specific purposes, such as supporting applications under Section 125, maintenance, or Section 200, complaints. Oaths Act, 1969, Sections 4 and 6 outline the administration of oaths and affirmations for affidavits, ensuring their sanctity. Indian Evidence Act, 1872, affidavits are admissible as evidence under Section 3, subject to the rules of relevancy and the court's discretion to call for cross-examination. An affidavit typically includes 1. Title and case details, identification of the court, case number, and parties involved. 2. Deponent's details, name, age, address, and occupation of the person making the affidavit, deponent. 3. Statement of facts, a clear, concise narration of facts within the deponent's personal knowledge or belief, numbered sequentially for clarity. 4. Oath or affirmation, a declaration that the contents are true to the best of the deponent's knowledge or belief. 5. Verification, a clause confirming the truthfulness of the statements, signed by the deponent. 6. Attestation, certification by an authorized officer, such as a notary public, confirming that the affidavit was sworn or affirmed before them. Affidavits must be drafted with precision, avoiding vague or hearsay statements, as they are subject to judicial scrutiny and may be challenged for authenticity or relevance. 59. Objectives of an affidavit. The affidavit serves multiple objectives in legal proceedings, reflecting its versatility and importance in the administration of justice. These objectives include: 1. Establishing facts. The primary objective of an affidavit is to present facts relevant to a case, enabling the court to ascertain the truth without requiring oral testimony in every instance. For example, in applications for interim injunctions under Order XXXIXCPC, affidavits provide the factual basis for the court's decision. 2. Providing evidence. Affidavits serve as documentary evidence, admissible under the Indian Evidence Act, 1872, particularly in interlocutory applications or summary proceedings. They streamline judicial processes by reducing the need for lengthy oral evidence. 3. Ensuring truthfulness. By requiring the deponent to swear or affirm the truth of the statements, affidavits promote honesty and deter false claims. The risk of perjury under Section 191 IPC acts as a safeguard against misrepresentation. 4. Facilitating expeditious justice. Affidavits enable courts to dispose of matters efficiently, especially in preliminary or procedural stages, such as applications for bail, maintenance, or stay of proceedings. This aligns with the principle of speedy justice under Article 21 of the Constitution. 5. Supporting pleadings. In drafting and pleading, affidavits corroborate the averments made in plaints, written statements, or applications, lending credibility to the parties' claims. For instance, in a suit for specific performance, an affidavit may support the plaintiff's claim of readiness and willingness. 6. Ensuring procedural compliance. Affidavits ensure compliance with statutory requirements, such as filing sworn statements in support of applications under Section 125 CRPC or petitions under the Hindu Marriage Act, 1955. 7. Protecting parties' interests. Affidavits allow parties to formally record their version of facts, protecting their legal rights and interests in proceedings where oral testimony may not be feasible. Affidavits are indispensable in various legal contexts, including civil suits, e.g., injunctions, declarations, criminal proceedings, e.g., bail, complaints, family law, e.g., maintenance, divorce, and administrative proceedings, e.g., affidavits for property transfers. Their versatility makes them a critical tool in drafting, pleading, and conveyancing, requiring law students to master their preparation. Landmark case, Babubhai Vithal Bhai Patel v Nandlal B. Patel, 2007, 10 SCC 144. The case of Babubhai Vithal Bhai Patel v Nandlal B. Patel is a seminal judgment that underscores the evidentiary value and procedural importance of affidavits in civil proceedings. The case involved a dispute over the validity of an affidavit filed in support of an application for interim relief 60 in a civil suit. The Supreme Court addressed the issue of whether an affidavit containing hearsay or unverified statements could be relied upon. The court made the following key observations: personal knowledge requirement. An affidavit must be based on the deponent's personal knowledge or belief, as required under Order 19 Rule 3 CPC. Statements based on hearsay or conjecture are inadmissible unless supported by documentary evidence or corroborated by other witnesses. Evidentiary value. Affidavits are admissible as evidence, but their weight depends on the credibility of the deponent and the veracity of the statements. Courts may direct cross-examination if the affidavit's contents are disputed. Procedural compliance. The affidavit must comply with the formal requirements of attestation and verification to be legally valid. Non-compliance. such as lack of proper attestation, may render the affidavit defective. Perjury as a deterrent. The court emphasized that false statements in an affidavit attract penalties for perjury, reinforcing the sanctity of sworn declarations. This judgment clarified the procedural and evidentiary standards for affidavits, highlighting their role in ensuring truthfulness and fairness in judicial proceedings. It serves as a guiding precedent for drafting affidavits, emphasizing clarity, authenticity, and adherence to legal norms. Procedure for drafting and filing an affidavit. The preparation and filing of an affidavit involve the following steps. 1. Drafting the content. The affidavit should be drafted in clear, concise language, with facts numbered sequentially. It must avoid legal arguments, opinions, or extraneous material, focusing solely on relevant facts. 2. Verification clause. The deponent must include a verification clause, stating that the contents are true to their knowledge or belief, specifying which paragraphs are based on knowledge and which on information. 3. Oath or affirmation. The deponent must swear or affirm the affidavit before an authorized officer, such as a notary public or oath commissioner, as per the Oaths Act, 1969. 4. Attestation. The authorized officer attests the affidavit, confirming that it was sworn or affirmed in their presence, and affixes their seal and signature. 5. Filing with the court. The affidavit is filed along with the relevant application, plaint, or petition, accompanied by annexures, e.g., documents supporting the facts. Courts may reject affidavits that are defective, such as those lacking proper attestation or containing irrelevant or false statements. The drafting process requires precision to ensure compliance with procedural rules and judicial expectations. 61. Draft affidavit. Below is a sample affidavit in support of an application for interim maintenance under Section 125 CRPC, based on a hypothetical scenario. The draft adheres to the format prescribed under the CPC and CRPC in the Court of the Judicial Magistrate First Class, City Affidavit in support of application under Section 125 of the Criminal Procedure Code, 1973. I. SMT Priya Sharma, aged 32 years, wife of Shri Rohan Sharma, resident of house number 123-1. That I am the applicant in the above-mentioned application and am fully conversant with 2. That I was legally married to the respondent, Shri Rohan Sharma, on May 10, 2018 at 3. That a minor daughter, Miss Ananya Sharma, aged 6 years, was born out of the said wedlow. 4. That since January 2024, the respondent has neglected and refused to maintain me and OU. 5. That I am unemployed and have no independent source of income to support myself or my D6. That the respondent is employed as a manager at company name, earning a monthly salary. 7. That the facts stated in paragraphs 1 to 6 above are true to my personal knowledge, and verification. I, the above-named deponent, do hereby verify that the contents of paragraphs 1 to 7 of th solemnly affirmed at City on this 15th day of June 2025. SMT Priya Sharma deponent before me, Notary Public / Oath Commissioner seal and signature. Analysis of the draft affidavit. The sample affidavit adheres to the procedural and substantive requirements for affidavits under the CRPC and CPC, incorporating clear identification. The deponent's details and the context of the application are clearly stated. 62 numbered paragraphs. Facts are presented sequentially, ensuring clarity and ease of reference. Personal knowledge. The affidavit is based on the deponent's personal knowledge, with supporting documents annexed to enhance credibility. Verification and attestation. The verification clause confirms the truthfulness of the statements, and the attestation ensures compliance with the Oaths Act, 1969. The draft is concise, focused, and legally sound, making it a practical example for students learning the art of drafting affidavits in legal practice. 63. Question 13, Draft a bail application, IPC 307, draft a bail application on behalf of the accused in the case of 307, Indian Penal Code. In this case, other CO accused has already been released on bail by the court. Legal framework: bail under Section 437 CRPC and Section 307 IPC. Section 437 CRPC governs bail in non-bailable offenses, such as Section 307 IPC, which prescribes punishment for attempt to murder, imprisonment up to 7 years or life imprisonment if hurt is caused. Key provisions include: Section 437, 1. A magistrate may grant bail for non-bailable offenses unless there are reasonable grounds to believe the accused is guilty of an offense punishable with death or life imprisonment. Section 437, 3. For offenses punishable with 7 years or more, conditions may be imposed to ensure the accused attendance, non-interference with investigation, and non-repetition of the offense. Parity principle: courts often grant bail to an accused if CO accused with similar roles have been released, as per Kailash Nath v. State of UP, 1985, CRILJ 1528. Section 307 IPC requires proof of intent or knowledge to cause death, making bail decisions hinge on the gravity of the offense, evidence, and the accused role. The judiciary balances the accused right to liberty, Article 21, with public safety and the investigation's integrity. Key principles from leading cases: Gurcharan Singh v. State, Delhi Administration, Air 1978 SC 179. The Supreme Court held that bail decisions must consider the nature of the offense, evidence, risk of absconding, and tampering with witnesses. Courts have wide discretion but must exercise it judiciously. Prahlad Singh Bhatti v. NCT of Delhi, 2001, 4 SCC 280, the court emphasized that bail in serious offenses like Section 307 IPC requires careful scrutiny of the accused role and the case's circumstances, but mechanical denial violates Article 21. Aslam Babalal Desai v. State of Maharashtra, 1992, 4 SCC 272, the court underscored the principle of parity, stating that if CO accused with similar roles are granted bail, denying bail to others may be discriminatory unless justified. These cases guide the drafting process, ensuring the bail application addresses the accused role, parity with the CO accused, and mitigating factors to persuade the court. Drafting the bail application, structure and strategy. Drafting a bail application under Section 437 CRPC requires 64 clarity, clearly state the accused details, offense, and grounds for bail. Statutory basis, invoke Section 437 CRPC and emphasize compliance with legal criteria. Factual narrative, highlight the accused limited role, lack of criminal history, and parity with the CO accused. Prayers, seek bail with reasonable conditions, ensuring cooperation with the investigation. The application must be supported by an affidavit verifying facts and annexures, e.g., bail order of CO accused. Below is the drafted bail application, followed by annotations explaining drafting choices. Drafted bail application in the Court of the Sessions Judge, City, State Criminal Miscellaneous Application No. __ of 2025 application under Section 437 of the Code of Criminal Procedure, 1973 for grant of bail in the matter of Shri Anil Kumar, S/O Shri Ramesh Kumar, aged 30 years, R/O address, City, State, presently in judicial custody at jail name. Versus State of State, through the Public Prosecutor, City, State. Most respectfully Shawith, applicant/accused respondent 1. That the applicant is an accused inferno. Number, dated e.g., March 10, 2025, registered at police station, City, under Section 307 read with Section 34 of the Indian Penal Code, 1860, and is presently in judicial custody since e.g., March 15, 2025. 2. That the allegations in the first state that on e.g., March 9, 2025, the applicant, along with CO accused Shri Vikram Singh, was involved in an altercation with the complainant, Shri Sunil Sharma, resulting in injuries. The applicant is alleged to have acted with intent to cause death, invoking Section 307 IPC. 3. That the applicant is innocent and has been falsely implicated due to a prior dispute with the complainant over e.g., a property matter. The applicant denies any intention or act to cause death, as no lethal weapon was used, and the injuries sustained by the complainant were minor, as per the medical report annexed as Annex UR A65-4. That the CO accused, Shri Vikram Singh, who played a similar role in the alleged incident, was granted bail by this Honorable Court by the order dated e.g., April 20, 2025 in Criminal Miscellaneous Application No. Number. A copy of the bail order is annexed as Annex UR B5. That the applicant has no criminal history and is a law-abiding citizen, employed as e.g., a shopkeeper, with deep roots in society, residing at address with his family. There is no risk of the applicant absconding or tampering with evidence. 6. That the investigation is complete, and a charge sheet has been filed on e.g., May 10, 2025. The applicant's continued detention serves no purpose, as the trial is likely to be prolonged. 7. That the applicant undertakes to cooperate with the investigation, attend court proceedings, and comply with any conditions imposed by this Honorable Court. 8. That the grant of bail to the CO accused establishes parity, as per Aslam Babalal Desai v. State of Maharashtra, 1992, 4 SCC 272, and denying bail to the applicant would be discriminatory, given his similar role. 9. That the applicant's detention violates his right to personal liberty under Article 21, as prolonged custody without trial is unjust, per Prahlad Singh Bedi v. NCT of Delhi, 2001, 4 SCC 280. 10. That the applicant is willing to furnish surety and abide by conditions under Section 437, 3, CRPC to ensure his presence and non-interference with the trial. Prayer. It is most respectfully prayed that this Honorable Court may be pleased to, a. Grant bail to the applicant in for no. Number, dated e.g., March 10, 2025, under Section 307 read with Section 34 IPC, on such terms and conditions as deemed fit. B. Pass any other order, s. as this Honorable Court deems fit and proper in the interest of justice. Place, City Advocate for Applicant Affidavit, date, June 15, 2025 Advocate's name, Enrollment No. Affidavit I, Anil Kumar, S/O Ramesh Kumar, aged 30 years, R/O address, City, presently in judicial custody at jail name, do hereby solemnly affirm and state on oath as follows. 1. That I am the applicant in the above application and competent to swear this affidavit. 2. That the contents of paragraphs 1 to 10 of the application are true to my knowledge and belief. 66.3. That I am innocent, have no criminal history, and undertake to comply with all court conditions if granted bail. 4. That I have not suppressed any material facts. Deponent verification, verified at City on June 15, 2025, that the contents of this affidavit are true to my knowledge. Anil Kumar annotations on drafting choices jurisdiction. The application is addressed to the Sessions Court, as Section 307 IPC involves a serious offense triable by a sessions judge, per Section 437 CRPC factual narrative. Paragraphs 1-3 outline the allegations and the applicant's defense, minor injuries, no lethal weapon, weakening the prosecution's case under Section 307 IPC. Parity principle, the bail order of the CO accused, Annex UR B, is cited, invoking Aslam Babalal Desai to argue non-discrimination. Mitigating factors, the applicant's lack of criminal history, societal roots, and completed investigation reduce the risk of absconding or tampering, aligning with Gurcharan Singh. Constitutional ground, Article 21 is invoked to emphasize liberty, supported by Prahlad Singh Bedi. Affidavit, verifies facts, enhancing credibility and complying with procedural norms. Language, formal, persuasive language with numbered paragraphs ensures clarity and readability. Procedural aspects filing, The application is filed with the Sessions Court, accompanied by annexures, e.g., medical report, CO accused's bail order, and the affidavit. Court fees, if applicable, are paid as per state rules. Hearing: the court hears arguments from the applicant's counsel and the public prosecutor, assessing the offense's gravity, evidence, and parity. Conditions: if granted, bail may include conditions under Section 437(3), such as furnishing surety, reporting to police, or not contacting witnesses. Rejection and appeal: if rejected, the applicant may approach the High Court under Section 439 CRPC or the Supreme Court under Article 136, as seen in Kalyan Chandra Sarkar v. Rajesh Ranjan, 2004, 7 SCC 528. 67 Jurisprudential insights. Bail jurisprudence balances individual liberty with societal interests. Gurcharan Singh established that bail is a rule and jail an exception in non-bailable offences, except where serious risks exist. The parity principle, as in Aslam Babalal Desai, ensures fairness among CO accused, preventing arbitrary detention. Prahlad Singh Bhatti underscores that mechanical denial of bail in serious offences violates Article 21, particularly when evidence is weak or the investigation is complete. The bail application thus leverages these principles to argue for the applicant's release, emphasizing his minimal role and the CO accused's bail. Practical considerations. Evidence assessment: the applicant's counsel must review the FIR, medical report, and charge sheet to highlight weaknesses in the prosecution's case, e.g., minor injuries under Section 307 IPC. Parity argument: the CO accused's bail order is critical, requiring a certified copy to strengthen the plea. Conditions. Compliance: the applicant must be prepared to meet conditions like surety or travel restrictions to secure bail. Social context: in Section 307 cases, courts scrutinize intent and injury severity. The applicant's counsel should emphasize mitigating factors, e.g., no prior enmity, no weapon. 68 Question 14, Memorandum of Criminal Appeal and Draft for Appeal Against Conviction U/S302/120B/34 IPC. What do you mean by Memorandum of Criminal Appeal? Drafted for the appeal against conviction U/S302/120B/34 IPC. Concept of Memorandum of Criminal Appeal. A Memorandum of Criminal Appeal is a formal legal document filed by an appellant seeking to challenge a conviction or sentence imposed by a lower court. It is a foundational pleading in appellate proceedings, governed primarily by the Code of Criminal Procedure, 1973, Cr.P.C., specifically sections 372 to 394. The memorandum outlines the grounds on which the appellant seeks to overturn the trial court's judgment, whether due to errors in law, fact, or procedure. It serves as a roadmap for the appellate court, summarizing the case, the errors alleged, and the relief sought. Purpose and importance. The primary purpose of the memorandum is to articulate the grounds of appeal clearly and concisely, enabling the appellate court to assess whether the trial court's decision warrants interference. It ensures that the appellant's grievances are systematically presented, adhering to the principles of natural justice and due process. The memorandum is crucial because it identifies errors in the trial court's judgment, such as misapplication of law, improper appreciation of evidence, or procedural irregularities. It invokes the appellate court's jurisdiction under Section 374 Cr.P.C. for appeals from convictions by sessions courts. It serves as a legal record, ensuring transparency and accountability in the appellate process. Legal framework. The drafting of a memorandum of criminal appeal is governed by Section 374 Cr.P.C., provides for appeals from convictions by a sessions court to the High Court. Section 382 Cr.P.C. mandates that every appeal be made in the form of a petition in writing, accompanied by a copy of the judgment or order appealed against. Section 383 Cr.P.C. governs appeals from jail, where the appellant is in custody. Section 384 CR.P.C. allows summary dismissal of appeals if the court finds no sufficient ground for interference. Additionally, the memorandum must comply with the rules of the respective High Court, such as the High Court Rules and Orders, which prescribe formats and procedural requirements. 69 Essential components. A memorandum of criminal appeal typically includes 1. Title and cause. Title specifies the court, parties involved, and the case number. 2. Statement of jurisdiction invokes the appellate court's authority under relevant CR.P.C. provisions. 3. Facts of the case, a concise summary of the case background, trial proceedings, and the impugned judgment. 4. Grounds of appeal, detailed legal and factual grounds challenging the trial court's decision. 5. Prayer, the relief sought, such as setting aside the conviction or sentence. 6. Annexures, copies of the trial court's judgment, evidence, and other relevant documents. 7. Affidavit, a sworn statement by the appellant or their counsel verifying the contents of the memorandum. Relevant legal provisions, sections 302, 120b, and 34 IPC. To contextualize the draft memorandum, it is essential to understand the substantive provisions under which the conviction is challenged. Section 302 IPC punishes murder with death or imprisonment for life and fine. It applies when the accused intentionally causes the death of another person. Section 120b IPC addresses criminal conspiracy, where 2 or more persons agree to commit an illegal act or a legal act by illegal means, punishable as per the offense conspired. Section 34 IPC imposes liability for acts done by several persons in furtherance of a common intention, making each person liable as if they committed the act alone. Landmark case, State of Maharashtra v. Sukhdev Singh. The case of State of Maharashtra v. Sukhdev Singh, Air 1992 SC 2100, is a seminal precedent relevant to appeals against convictions under sections 302, 120b, and 34 IPC. In this case, the Supreme Court addressed the principles governing common intention and conspiracy in a murder case. The appellants were convicted for murdering a police officer, with the prosecution relying on circumstantial evidence and the doctrine of common intention. The Supreme Court emphasized the necessity of proving a prearranged plan for invoking Section 34 IPC, the importance of distinguishing between mere presence and active participation in the crime. 70. The appellate court's duty to re-evaluate evidence when the trial court's findings are perverse or based on insufficient evidence. This case guides the drafting of the memorandum by highlighting the need to challenge the prosecution's evidence on common intention and conspiracy, especially when the conviction relies on circumstantial evidence or weak witness testimonies. Drafting a memorandum of criminal appeal. Below is a sample memorandum of criminal appeal drafted for an appeal against a conviction under sections 302, 120b, and 34 IPC, inspired by the principles laid out in State of Maharashtra v. Sukhdev Singh. The draft assumes a hypothetical case where the appellant, convicted by a sessions court, challenges the judgment on grounds of insufficient evidence, misapplication of law, and procedural irregularities. Sample memorandum in the High Court of Judicature at State Criminal Appellate Jurisdiction. Criminal Appeal. No. Number of year in the matter of, appellant's name, S/O father's name, resident of address, presently confined in jail. Name, appellant versus the state of state, through the public prosecutor, respondent. Appeal under Section 374 of the Code of Criminal Procedure, 1973 against the judgment and order dated date passed by the learned sessions judge, district, in sessions case no. Number convicting the appellant under sections 302, 120b, and 34 of the Indian Penal Code, 1860. Most respectfully showeth, 1. Statement of jurisdiction, that this honorable court has jurisdiction to hear and decide this appeal under section 374, 2, of the Code of Criminal Procedure, 1973, as the impugned judgment was passed by the learned sessions judge, district, convicting the appellant for offenses punishable under sections 302, 120b, and 34 IPC 2. Facts of the case: 71 on date, the appellant was charged with the murder of deceased's name, allegedly committed in furtherance of a criminal conspiracy and common intention with CO accused persons. The prosecution's case rested on circumstantial evidence, including the testimonies of witness names, alleged recovery of a weapon, and motive based on brief motive. The learned sessions judge, in Sessions case No. Vide judgment dated date, convicted the appellant and sentenced him to life imprisonment and a fine of Rs amount. The appellant submits that the impugned judgment is erroneous, unsustainable in law, and liable to be set aside for the reasons stated hereinafter. 3 grounds of appeal. The appellant respectfully submits the following grounds of appeal, without prejudice to one another: a. That the learned sessions judge erred in law and fact by convicting the appellant under Section 302 IPC without sufficient evidence to prove beyond reasonable doubt that the appellant caused the death of the deceased. b. That the prosecution failed to establish a prearranged plan or meeting of minds, as required under Section 120B IPC, rendering the conviction for criminal conspiracy legally untenable. c. That the application of Section 34 IPC was erroneous, as there was no evidence to demonstrate the appellant's active participation in furtherance of a common intention, contrary to the principles laid down in State of Maharashtra v. Sukhdev Singh, Air 1992 SC 2100. d. That the trial court improperly appreciated the evidence, particularly the testimonies of witness names, which were inconsistent, contradictory, and lacked corroboration. e. That the alleged recovery of the weapon was procedurally defective under Section 27 of the Indian Evidence Act, 1872, as it was not conducted in the presence of independent witnesses. f. That the trial court failed to consider the appellant's alibi, supported by evidence/alibi details, which created reasonable doubt about his involvement in the crime. g. That the chain of circumstantial evidence was incomplete, and the prosecution failed to exclude all possible hypotheses of the appellant's innocence, as required under Sharad Burdikant Sarda v. State of Maharashtra, Air 1984 SC 1622. h. That the trial court did not provide the appellant an adequate opportunity to cross-examine key witnesses, violating the principles of natural justice. For prayer, in view of the above, the appellant most humbly prays that this honorable court may be pleased to a. Set aside the judgment and order dated date passed by the learned sessions judge, district, in Sessions case No. 72, b. Acquit the appellant of all charges under Sections 302, 120b, and 34 IPC, c. Grant any other relief that this honorable court deems fit and proper in the interest of justice. Annex Yours, Annexure A, certified copy of the impugned judgment dated date. Annexure B, copies of relevant trial court records, including witness testimonies and exhibits. Annexure C, affidavit in support of the appeal. Verification: I, appellant's name, do hereby solemnly affirm and declare that the contents of the above memorandum are true to the best of my knowledge and belief, and no material fact has been concealed therefrom. Date, place signature, appellant's signature or counsel's signature, advocate for the appellant, advocate's name, enrollment number, contact details. Analysis of the draft: the above memorandum adheres to the procedural requirements under the CR.P.C. and High Court rules, ensuring clarity and precision. Key features include: jurisdictional clarity. The memorandum invokes Section 374, 2, CR.P.C., establishing the High Court's appellate jurisdiction. Grounds of appeal: the grounds are specific, addressing errors in law, e.g., misapplication of Section 34 IPC, and fact, e.g., inconsistent witness testimonies, supported by judicial precedents like State of Maharashtra v. Sukhdev Singh. Relevance of precedent: the reference to State of Maharashtra v. Sukhdev Singh strengthens the appeal by highlighting the need for clear evidence of common intention and conspiracy. Procedural compliance: The inclusion of annex years and a verification clause ensures compliance with sections 382 and 384 CR.P.C. 73. Question 15. Draft an application for claiming maintenance under Section 125 CRPC. Draft an application for claiming maintenance under Section 125 CRPC on behalf of Seema and her minor daughter aged 3 years from her husband Sahil. Legal framework, Section 125 CRPC. Section 125 CRPC is a secular provision aimed at preventing vagrancy and destitution by mandating maintenance for certain dependents. It applies to a wife unable to maintain herself, including a divorced wife who has not remarried, a legitimate or illegitimate minor child, below 18 years, unable to maintain themselves, parents unable to maintain themselves. The provision is summary in nature, allowing magistrates to grant maintenance based on the applicant's inability to self-sustain and the respondent's sufficient means. The maximum amount is not capped, but courts consider reasonableness, as clarified in Rajathai v. C. Ganesan, 1999, 6 SCC 326. The application must be filed in the appropriate judicial magistrate's court where either party resides. Key principles from leading cases: Savitri v. Govind Singh Rawat, AIR 1986 SC 984. The Supreme Court emphasized that Section 125 proceedings are quasi-civil, requiring prima facie proof of neglect or refusal to maintain. The court also upheld interim maintenance to prevent hardship during pendency. Bhagwan Dutt v. Kamla Devi, AIR 1975 SC 83. The court clarified that a wife's independent income does not disentitle her to maintenance unless it is sufficient for her sustenance. The husband's means and the wife's needs are balanced. Shamima Farooqi v. Shahid Khan, 2015, 5 SCC 705. The court underscored that maintenance must ensure a dignified standard of living, considering the husband's income and social status. These cases guide the drafting process, ensuring the application addresses neglect, financial need, and the respondent's capacity. Drafting the application, structure and strategy. Drafting an application under Section 125 CRPC requires clarity, use precise language to state facts and prayers. Statutory compliance, reference Section 125 CRPC and jurisdictional details. Factual basis, narrate the marriage, neglect, and financial distress. 74 prayers, specify maintenance amounts for the wife and child, including interim relief. The application must be supported by an affidavit verifying facts, as per procedural norms. Below is the drafted application, followed by annotations explaining drafting choices. Drafted application for maintenance in the Court of the Judicial Magistrate First Class, City, State. Application under Section 125 of the Code of Criminal Procedure, 1973 for grant of maintenance on behalf of SMT Seema, W/O Sahil, aged 28 years, R/O. Applicant's address, City, State. Kumari Ria, minor daughter, aged 3 years, through her mother and natural guardian, SMT Seema, R/O. Applicant's address, City, State. Against, Shri Sahil, S/O. Father's name, aged 32 years, R/O. Respondent's address, City, State. Most respectfully Shauth, 1. That the applicant number 1, SMT Seema, was lawfully married to the respondent, Shri Sahil, on date of marriage, e.g., May 15, 2018 as per Hindu rites and ceremonies at place of marriage. The marriage is subsisting, and a copy of the marriage certificate is annexed as Annexure A2. That out of the said wedlock, applicant number 2, Kumari Ria, was born on date of birth, e.g., June 10, 2022, who is a minor aged 3 years and resides with applicant number 1. A copy of the birth certificate is annexed as Annexure B3. That the respondent is employed as respondent's occupation, e.g., software engineer with employer's name, e.g., XYZ Private Limited, earning approximately Rs amount, e.g., 1,50,000 per month, as per credible information and pay slips obtained by applicant number 1, annexed as Annexure C4. That the respondent has neglected and refused to maintain the applicant's since date, e.g., January 2024, when he deserted applicant number 1 and the minor child without reasonable cause. The respondent has not provided any financial support thereafter. 5. That applicant number 1 is unemployed and has no independent source of income to maintain herself or applicant number 2. The applicants are wholly dependent on the respondent for their sustenance. 6. That the applicants are facing acute financial hardship, unable to afford basic necessities like food, clothing, medical care, and education for the minor child. Applicant number 1 has been compelled to reside with her parents, who are of modest means. 75.7. That the respondent, despite having sufficient means, has willfully neglected his legal obligation under Section 125 CRPC to maintain the applicants, causing them undue hardship and distress. 8. That applicant number 1 has made repeated requests to the respondent for maintenance, including a written notice dated date, e.g., February 10, 2024, but the respondent has failed to comply. A copy of the notice is annexed as Annexure D9. That the applicants require a monthly maintenance of Rs amount, e.g., 50,000 for applicant number 1 and Rs amount, e.g., 25,000 for applicant number 2 to meet their basic needs, considering the respondent's income and the prevailing cost of living. 10. That the applicants also seek interim maintenance under Section 125 CRPC to alleviate their immediate financial distress, as per the principles laid down in Savitri v. Govind Singh Rawat, Air 1986 SC 984. 11. That this application is filed in good faith, and the applicants have no other means to sustain themselves. The court has jurisdiction as the applicants reside within its territorial limits. Prayer. It is most respectfully prayed that this honorable court may be pleased to a. Grant monthly maintenance of Rs 50,000 to applicant number 1 and Rs 25,000 to applicant number 2, payable by the respondent from the date of this application. b. Grant interim maintenance of Rs 30,000 per month to the applicants pending disposal of this application. c. Direct the respondent to pay arrears of maintenance, if any, in a lump sum or installments. d. Pass any other order, s. as this honorable court deems fit and proper in the interest of justice. And for this act of kindness, the applicants shall ever remain grateful. Place, city date, e.g., June 15, 2025. Advocate for applicants. Advocate's name, enrollment no. Verification, I, SMT CMOT, applicant number 1, do hereby verify that the contents of paragraphs 1 to 11 are true to my personal knowledge and belief, and I have not suppressed any material facts. Verified at city on date. SMT CMOT Affidavit, Affidavit I, SMT CMOT, W/O Shri Sahil, aged 28 years, R/O address, do hereby solemnly affirm and state on oath as follows, 76-1. That I am applicant number 1 and the natural guardian of applicant number 2, competent to swear this affidavit. 2. That the contents of the accompanying application under Section 125 CRPC are true to my knowledge and belief. 3. That I have no independent income and am wholly dependent on the respondent for maintenance. 4. That the respondent has neglected to maintain me and my minor daughter since date. 5. That I have not suppressed any material facts and have filed this application in good faith. Deponent verification, verified at city on date that the contents of this affidavit are true to my knowledge. SMT CMA annotations on drafting choices jurisdiction. The application specifies the court's territorial jurisdiction, as required under Section 126 CRPC, based on the applicant's residence. Factual narrative, paragraphs 1-8 establish the marriage, birth of the child, respondent's income and neglect, supported by annexures, e.g., marriage certificate, payslips. This aligns with Bhagwan Dutt v. Kamla Devi, emphasizing proof of neglect and financial need. Maintenance amount, The requested amounts, Rs 50,000 for SEMA, Rs 25,000 for RIA, are justified by the respondent's income and cost of living, per Shamima Farooqi v Shahid Khan. Interim maintenance. The prayer for interim relief invokes Savitri v Govind Singh Rawat, ensuring immediate relief during pendency. Affidavit. The affidavit verifies facts, enhancing credibility and complying with procedural norms. Language. Formal, respectful language is used, with concise paragraphs for readability, as per drafting principles. Procedural aspects. Filing. The application is filed with the Judicial Magistrate First Class, accompanied by annex years and the affidavit. A court fee, if applicable, must be paid as per state rules. 77. Question 16. Draft a notice to be served by a landlord on his tenant. Draft a notice to be served by a landlord on his tenant, terminating his tenancy and asking to vacate the leased premises. Legal framework. Termination of tenancy. The termination of tenancy in India is primarily governed by Section 106 of the TPA, which prescribes the notice period for terminating a lease in the absence of a contract to the contrary. Key provisions include, Section 106, 1. A lease for agricultural or manufacturing purposes requires 6 months' notice, while a lease for other purposes, e.g., residential or commercial, requires 15 days' notice, unless otherwise agreed. Section 106, 3. The notice must be in writing, signed by or on behalf of the person giving it, and served personally, by post, or by affixing it to the premises. Section 111, a lease may be terminated by various modes, including expiration of notice, forfeiture, or mutual agreement. Additionally, state-specific rent control laws, such as the Delhi Rent Control Act, 1958, or the Maharashtra Rent Control Act, 1999, impose additional requirements, such as grounds for eviction, e.g., bona fide need, non-payment of rent. The notice must comply with both TPA and applicable rent control legislation to be valid. Key principles from leading cases: Vidhanapal Chettiar v Yazide Amal, Air 1979 SC 1745. The Supreme Court held that under rent control laws, a landlord need not prove grounds for eviction in the notice unless required by the statute. A notice under Section 106 TPA is sufficient to terminate the tenancy, subject to statutory protections. Ratan Lal v Bardish Chander, Air 1976 SC 588. The court clarified that a notice under Section 106 TPA must clearly express the landlord's intention to terminate the tenancy and specify the date of termination. Ambiguity renders the notice invalid. Manjai Lal v Sugan Chand, Air 1965 SC 101. The court emphasized that service of notice must be proven, either through personal delivery, registered post, or affixation, as per Section 106, 3. These cases guide the drafting process, ensuring the notice is precise, legally compliant, and effectively served. 78. Drafting the notice, structure and strategy. Drafting a notice for termination of tenancy requires clarity. The notice must unequivocally state the intention to terminate the tenancy and the date by which the tenant must vacate. Statutory compliance. Reference Section 106 TPA and any applicable rent control law, specifying the notice period and grounds, if required. Factual basis. Include details of the tenancy agreement, premises, and reasons for termination, e.g., non-payment of rent, landlord's need. Service. Ensure the notice is served as per statutory requirements, with proof of service retained. The notice should be concise yet comprehensive, avoiding unnecessary legal jargon. Below is the drafted notice, followed by annotations explaining drafting choices. Drafted notice for termination of tenancy. Notice under Section 106 of the Transfer of Property Act, 1882 to Shri Anil Kumar, S/O father's name, R/O flat no 3A, Sunshine Apartments, address, city, state, PIN code. Subject, termination of tenancy and demand to vacate leased premises. Sir, under instructions from and on behalf of my client, Shri Rajesh Sharma, S/O father's name, R/O landlord's address, city, state, I hereby serve you with the following notice. 1. That my client is the absolute owner and landlord of the premises situated at Flat No. 3A, Sunshine Apartments, address, city, state, hereinafter referred to as the leased premises. 2. That you, Shri Anil Kumar, are a tenant in the leased premises under a tenancy agreement dated e.g., January 1, 2023, executed between you and my client, for a monthly rent of Rs e.g., 25,000. A copy of the tenancy agreement is available with my client. 3. That the tenancy is a month-to-month tenancy for residential purposes, terminable by 15 days notice under Section 106 of the Transfer of Property Act, 1882, as no contrary provision exists in the tenancy agreement. 4. That my client requires the leased premises for his bona fide personal use, as he intends to reside therein with his family, who are presently residing in rented accommodation elsewhere. 79.5. That you have defaulted in payment of rent for the months of e.g., April 2025 to June 2025, amounting to Rs e.g., 75,000, despite repeated demands, including a reminder letter dated e.g., May 1, 2025. 6. That, in view of the above, my client hereby terminates your tenancy with respect to the leased premises with effect from e.g., June 30, 2025, being 15 days from the date of receipt of this notice. 7. That you are hereby called upon to vacate and hand over vacant and peaceful possession of the leased premises to my client on or before e.g., June 30, 2025, failing which my client shall initiate appropriate legal proceedings for eviction and recovery of arrears of rent, holding you liable for all costs and consequences. Please take note that this notice is served in accordance with Section 106 of the Transfer of Property Act, 1882, and the e.g., Delhi Rent Control Act, 1958, if applicable. You are advised to comply to avoid legal action. Place, city date, June 15, 2025. Advocate for landlord. Advocate's name, enrollment no. Contact details. Mode of service, by registered post with acknowledgement due at tenant's address. By affixation at the leased premises, if personal service is refused. Annotations on drafting choices. Statutory reference, the notice invokes Section 106 TPA, specifying the 15-day notice period for a month-to-month residential tenancy, aligning with Ratan Lal v Vardish Chander for clarity in termination date. Grounds for termination. 2 grounds are stated: bona fide need and non-payment of rent to strengthen the landlord's case under rent control laws, as per Vidhanapal Chettiar v Yezide Amal. While TPA does not mandate grounds, rent control statutes often do. Factual details. The notice includes the tenancy agreement date, rent amount, and premises description to establish the landlord-tenant relationship, enhancing enforceability. Service details. The mode of service, registered post and affixation, complies with Section 106(3) TPA, ensuring proof of service, as emphasized in Manjai Lal v Sugan Chand. Language. The notice uses formal, respectful language, avoiding ambiguity, with numbered paragraphs for readability, as per drafting best practices. Consequences. The notice warns of legal action for non-compliance, reinforcing its seriousness without being coercive. 80 Procedural aspects. Preparation. The notice must be drafted on the landlord's or advocate's letterhead, signed by the landlord or their authorized advocate. Service. Service is critical for validity. The notice should be sent via * registered post with acknowledgement due, AD, to the tenant's last known address. * speed post or courier with tracking. * personal delivery with assigned acknowledgement. * affixation at the premises if the tenant refuses service, with witnesses, as per Parvinder Singh v Renu Gautam, 2004, 4 SCC 794. Retain copies of the notice, postal receipts, and AD cards as evidence. Follow up. If the tenant does not vacate, the landlord may file an eviction suit under the TPA and rent control law, relying on the notice as a prerequisite. Time calculation: the notice period excludes the date of service and includes the last day, as clarified in BP Khemka Private Limited v Birendra Kumar Bhaumik, AIR 1987 SC 1010. Jurisprudential insights: the notice to terminate tenancy reflects the delicate balance between the landlord's rights and the tenant's protections under Indian law. Vidhanapal Chettiar v Yezuday Amal underscores that rent control laws supplement, not supplant, the TPA, ensuring tenants are not arbitrarily evicted. However, Prabhakara Adiga v Gowri, 2017, 4 SCC 600, highlights that a defective notice, e.g., incorrect period or vague intent, can derail eviction proceedings, emphasizing drafting precision. The notice also aligns with constitutional principles under Article 300A, safeguarding property rights while respecting statutory tenant protections. Practical considerations: tenancy agreement: review the agreement for any specific termination clauses, as they override Section 106 TPA to the extent. For instance, a fixed-term lease might require mutual consent for early termination unless otherwise stipulated. State-specific nuances: in states with rent control, e.g., Uttar Pradesh, grounds like non-payment or subletting must be explicitly stated, as per local statutes. In states without rent control, TPA governs exclusively. Documentation: retain evidence of rent defaults, prior demands, or landlord's need to strengthen the notice's foundation for eviction suits. Cultural sensitivity: in practice, tenants may resist eviction due to socio-economic factors. The notice should be firm yet professional to encourage compliance or negotiation. 81 Question 17, Draft a public interest litigation related to stubble burning and air pollution. Draft a public interest litigation related to stubble burning and air pollution. Legal framework: environmental law and pills in India are filed under Article 32, Supreme Court, or Article 226, High Courts, of the Constitution, seeking remedies for violations of fundamental rights or public interest issues. Air pollution, including that caused by stubble burning, implicates, Article 21, the right to life includes the right to a clean and healthy environment, as established in Subhash Kumar v State of Bihar, AIR 1991 SC 420. Environmental statutes, the Air, Prevention and Control of Pollution, Act, 1981, mandates pollution control boards to regulate air quality. The Environment, Protection, Act, 1986, empowers the central government to take measures to protect the environment. The National Green Tribunal Act, 2010, provides a specialized forum for environmental disputes. Public Trust Doctrine: the state holds natural resources in trust for public benefit, as articulated in M.C. Mehta v. Kamal Nath, 1997, 1 SCC 388. Stubble burning, a practice prevalent in Punjab and Haryana, contributes significantly to air pollution, particularly PM 2.5 levels, violating citizens' rights to health and a clean environment. APIL can seek judicial directions to enforce environmental laws and promote sustainable agricultural practices. Key principles from leading cases: M.C. Mehta v. Union of India, AIR 1987 SC 1086. The Supreme Court expanded the scope of Article 21 to include environmental rights, directing authorities to control pollution from industries and vehicles. Vellore Citizens Welfare Forum v. Union of India, 1996, 5 SCC 647, the court introduced the precautionary principle and polluter pays principle, mandating sustainable development and strict enforcement of environmental laws. T. Ngode Barman Thirumal Pad v. Union of India, 2002, 10 SCC 606, the court issued continuing mandamus to monitor environmental compliance, a remedy suitable for ongoing issues like stubble burning. These cases guide the drafting process, ensuring the PIL addresses fundamental rights violations, seeks systemic reforms, and invokes judicial oversight. 82. Drafting the pill, structure and strategy. Drafting a pill requires clarity, clearly articulate the public interest issue and the relief sought. Constitutional basis, invoke Articles 32/226 and fundamental rights, e.g., Article 21. Factual foundation, provide evidence of the issue, e.g., air quality data, health impacts, and state inaction. Prayers, seek specific, actionable directions, including policy reforms and monitoring mechanisms. The pill must be supported by affidavits, annexures, e.g., reports, studies, and comply with court rules, e.g., Supreme Court Rules, 2013. Below is the drafted pill, followed by annotations explaining drafting choices. Drafted public interest litigation in the Supreme Court of India, original civil jurisdiction, public interest litigation no. __ of 2025 under Article 32 of the Constitution of India in the matter of Eco Justice Foundation, through its Secretary, Shri Vikram Singh, R/O address, New Delhi 110,001. Versus Petitioner 1. Union of India, through the Secretary, Ministry of Environment, Forest and Climate Change, New Delhi 110,003. 2. State of Punjab, through the Chief Secretary, Chandigarh 160,001. 3. State of Haryana, through the Chief Secretary, Chandigarh 160,001. 4. Central Pollution Control Board, through its Chairperson, New Delhi 110,032. Respondents 83 to the Honourable Chief Justice of India and his companion Justices of the Supreme Court of India most respectfully showeth, 1. That the petitioner, Eco Justice Foundation, is a registered non-governmental organization working for environmental protection and public health, duly authorized to file this pill under Article 32 for enforcement of fundamental rights. 2. That this pill addresses the grave issue of air pollution caused by stubble burning in Punjab and Haryana, which severely impacts air quality in Delhi NCR and northern India, violating citizens' right to life and health under Article 21. 3. That stubble burning, the practice of burning crop residue post-harvest, occurs annually between September and November, releasing particulate matter, PM2.5, PM10, carbon monoxide, and other pollutants. As per the Central Pollution Control Board, CPCB, data for 2024, stubble burning contributed to 30–40% of Delhi's PM2.5 levels during October–November, with air quality index, AQI, exceeding 400, hazardous. 4. That the resultant air pollution causes respiratory illnesses, cardiovascular diseases, and premature deaths. A 2023 Lancet study estimated 1.67 million deaths annually in India due to air pollution, with northern states disproportionately affected. Copies of the CPCB report and Lancet study are annexed as Annexure A and Annexure B5. That the respondents have failed to effectively enforce the Air, Prevention and Control of Pollution, Act, 1981, and the Environment, Protection, Act, 1986, despite statutory mandates to regulate air quality and penalize polluters. 6. That the Supreme Court, in MC Mehta v Union of India, WP, C. No. 13029/1985, directed measures to curb Delhi's air pollution, including stubble burning. However, inadequate implementation, lack of farmer support, and weak enforcement persist. 7. That the respondents have not adequately promoted alternatives to stubble burning, such as subsidized crop residue management, CRM, machines, biodecomposer technologies, or incentives for sustainable practices, despite schemes like the Crop Residue Management Scheme, 2018. 8. That the petitioner has made representations to the respondents, including a letter dated e.g., August 1, 2024 to the Ministry of Environment, urging action, but no effective response has been received. A copy is annexed as Annexure C9. that the inaction violates the precautionary principle and polluter pays principle, as enunciated in Vellore Citizens Welfare Forum v Union of India, 1996, 5 SCC 647, and the Public Trust Doctrine. 10. That the petitioner has no personal interest in this matter and seeks relief in public interest to protect the environment and public health. Grounds: 84, a. Violation of Article 21, as air pollution from stubble burning deprives citizens of a clean and healthy environment. b. Failure to enforce the Air Act, 1981, and Environment Act, 1986, constituting dereliction of statutory duty. c. Non-compliance with judicial directions in MC Mehta v Union of India and related cases, undermining environmental governance. d. Breach of international commitments under the Paris Agreement, 2015, to reduce emissions and promote sustainability. Prayer: it is most respectfully prayed that this honorable court may be pleased to a. Issue a writ of mandamus directing the respondents to strictly enforce laws prohibiting stubble burning, including penal action under the Air Act, 1981. b. Direct the states of Punjab and Haryana to provide subsidized CRM machines and biodecomposers to 100% of farmers by e.g., August 2026. c. Constitute a high-level committee to monitor stubble burning and air quality, reporting to this court quarterly, as per T. N. Godavarman Thirumal Pad v Union of India. d. Direct the Union of India to develop a national policy on crop residue management within 6 months. e. Award compensation to affected communities under the polluter pays principle, to be recovered from defaulting entities. f. Pass any other order, s. as deemed fit in the interest of justice. Place: New Delhi. Advocate for Petitioner Affidavit. Date: June 15, 2025. Advocate's name: Enrollment No. Affidavit I. Vikram Singh, Secretary, Eco Justice Foundation, aged 45 years, R/O address, New Delhi, do hereby solemnly affirm and state on oath as follows: 1. That I am the petitioner's authorized representative, competent to swear this affidavit. 2. That the contents of the accompanying pill are true to my knowledge, based on official reports and studies annexed. 3. That the petitioner has no personal interest and files this pill in public interest. 4. That no material facts have been suppressed. 85. Deponent verification, verified at New Delhi on June 15, 2025, that the contents of this affidavit are true to my knowledge. Vikram Singh. Annotations on drafting choices. Jurisdiction: the pill invokes Article 32, filed in the Supreme Court, as air pollution is a national issue affecting fundamental rights, aligning with MC Mehta v Union of India. Petitioner's locus standi: a registered NGO is chosen to establish credibility and public interest, per SP Gupta v Union of India, Air 1982 SC 149. Factual basis: CPCB data and Lancet study provide empirical evidence, strengthening the petition's foundation, as required in pills. Grounds: constitutional, Article 21, statutory, Air Act, Environment Act, and judicial precedents are cited, ensuring legal robustness. Prayers: specific, actionable reliefs, e.g., subsidies, committee, are sought, with a continuing mandamus for oversight, per T. N. Godavarman Thirumal Pad. Affidavit: verifies facts, enhancing credibility and complying with Supreme Court rules, 2013. Language: formal, persuasive language is used, with numbered paragraphs for clarity, as per drafting best practices. Procedural aspects: filing: the pill is filed with the Supreme Court Registry, accompanied by annexures, affidavit, and court fees, as per Supreme Court Rules, 2013. A synopsis and list of dates are included. Service: respondents are served notice through the registry, ensuring due process. Evidence: annexures, CPCB reports, studies, and potential expert affidavits support the petition. Respondents may file counter affidavits. Admissibility: the court assesses locus standi, public interest, and non-political nature, as per State of Uttaranchal v Balwant Singh Shofal, 2010, 3 SCC 402. 86 Jurisprudential insights. Pills have transformed environmental jurisprudence in India, expanding Article 21 to encompass environmental rights. Vellore Citizens Welfare Forum introduced Sustainable Development Principles, while Indian Council for Enviro-Legal Action v Union of India, 1996, 3 SCC 212 reinforced the polluter pays principle. Stubble burning, a socio-economic and environmental challenge, requires judicial intervention to balance farmers' livelihoods with public health. The pill aligns with India's international obligations under the Paris Agreement and constitutional mandates under Article 48A and 51A, g. Practical considerations. Farmer sensitivity. The pill seeks subsidies and alternatives to avoid penalizing farmers, acknowledging their economic constraints. Interstate coordination, involving Punjab, Haryana, and the Union ensures a holistic approach, as stubble burning is a regional issue. Scientific evidence, reliance on CPCB and Lancet data strengthens the petition's credibility, avoiding speculative claims. Continuing mandamus, a monitoring committee ensures sustained compliance, addressing enforcement gaps noted in prior cases. 87 Question 18, Writ of certiorari and draft petition. What is writ of certiorari? Draft a petition for writ of certiorari. Concept of writ of certiorari. The term certiorari derives from Latin, meaning to be certified or to be informed. In the Indian legal context, a writ of certiorari is a prerogative writ issued by a superior court, high court or supreme court, to quash the order or decision of a subordinate court, tribunal, or quasi-judicial authority when it has acted without jurisdiction, exceeded its jurisdiction, or committed an error apparent on the face of the record. It is a supervisory tool aimed at ensuring that justice is administered within the bounds of law. Purpose and scope. The primary purpose of a writ of certiorari is to correct jurisdictional errors and ensure that subordinate authorities act within their legal limits. According to Surya Dev Rai v Ramchandar Rai, Air 2003 SC 3044, the Supreme Court clarified that certiorari lies to correct errors of jurisdiction, such as acting without or in excess of jurisdiction. Errors apparent on the face of the record, including misapplication of law or disregard of statutory provisions. Violations of the principles of natural justice, such as denial of a fair hearing or bias. The writ does not permit reappreciation of evidence or correction of mere errors of fact unless they result in a miscarriage of justice. It is not an appellate remedy but a supervisory one, ensuring the integrity of the judicial process. Legal framework. The writ of certiorari is grounded in Article 32 of the Constitution, empowers the Supreme Court to issue writs, including certiorari, for the enforcement of fundamental rights. Article 226 of the Constitution, grants High Courts broader powers to issue writs, including certiorari, for the enforcement of fundamental rights and for any other purpose, such as correcting errors of subordinate courts. High Court rules. Each High Court prescribes procedural rules for filing writ petitions, including format, annexures, and court fees. The scope of certiorari was delineated in Hari Vishnu Kamath v Ahmed Ishaq, Air 1955 SC 233, where the Supreme Court held that certiorari can be issued to correct errors of law or jurisdiction but not to re-evaluate factual findings unless they are perverse. 88 Essential components of a writ petition. A petition for a writ of certiorari typically includes 1. Title and cause. Title specifies the court, parties involved, and the nature of the petition. 2. Statement of jurisdiction, invokes the court's authority under Article 226 or 32. 3. Facts of the case, a concise summary of the background, proceedings, and the impugned order. 4. Grounds for issuance of writ, detailed legal and procedural grounds challenging the impugned order. 5. Prayer, the relief sought, such as quashing the impugned order or issuing directions. 6. Annexures, copies of the impugned order, relevant documents, and evidence. 7. Affidavit, a sworn statement verifying the petition's contents. Landmark case, Surya Dev Rai v Ramchandar Rai. The case of Surya Dev Rai v Ramchandar Rai, Air 2003 SC 3044, is a seminal precedent on the scope of certiorari. In this case, the Supreme Court addressed the distinction between certiorari and appeal, emphasizing that certiorari lies only to correct jurisdictional errors or errors apparent on the face of the record. The case arose from a civil dispute where a lower court's order was challenged for exceeding its jurisdiction. The Supreme Court held, certiorari is available when a court or tribunal acts without jurisdiction, in excess of jurisdiction, or fails to exercise jurisdiction vested in it. Errors of law apparent on the face of the record, such as misinterpretation of a statute, justify the issuance of certiorari. The writ does not extend to correcting factual errors unless they result in a miscarriage of justice. This case guides the drafting of the petition by highlighting the need to focus on jurisdictional errors and legal infirmities, avoiding arguments that seek reappreciation of evidence. Drafting a petition for writ of certiorari. Below is a sample petition for a writ of certiorari filed in a high court under Article 226, challenging an order of a subordinate court on grounds of jurisdictional error and violation of natural justice. The draft assumes a hypothetical case where a civil court's order in a property dispute is challenged, inspired by the principles in Surya Dev Rai v Ramchandar Rai. 89 Sample petition in the High Court of Judicature at State Extraordinary Civil Writ Jurisdiction. Writ petition, civil, no. Number of year in the matter of, petitioner's name, S/O father's name, resident of address, petitioner versus Pondant 1's name, resident of address, 1. The state of state, through the district magistrate, district, 2. The presiding officer, civil court, district, respondent's petition under Article 226 of the Constitution of India for issuance of a writ of certiorari to quash the order dated date passed by the civil court, district, in civil suit no. Number. Most respectfully showeth, 1 statement of jurisdiction, that this honorable court has jurisdiction to entertain and decide this petition under Article 226 of the Constitution of India, as the impugned order dated date passed by the civil court, district, involves errors of jurisdiction and violations of natural justice, warranting the issuance of a writ of certiorari. 2 Facts of the case. The petitioner filed civil suit no. Number in the civil court, district, seeking a declaration of title over property description and a permanent injunction against respondent number 1. The suit was contested by respondent number 1, who claimed ownership based on brief claim. On date, the civil court passed an order dismissing the petitioner's suit, holding that the petitioner failed to establish title and that the court lacked jurisdiction to adjudicate the matter due to reasons cited by court. 90. The petitioner submits that the impugned order is illegal, arbitrary, and unsustainable in law for the reasons stated hereinafter. 3 Grounds for issuance of writ. The petitioner respectfully submits the following grounds, without prejudice to one another: a. That the civil court acted without jurisdiction by dismissing the suit on the ground of reasons cited by court, which is contrary to the provisions of the relevant statute, e.g., Transfer of Property Act, 1882. b. That the impugned order contains an error apparent on the face of the record, as the court misinterpreted relevant legal provision, contrary to the principles laid down in Surya Dev Rai v Ramchandar Rai, Air 2003 SC 3044. c. That the civil court violated the principles of natural justice by denying the petitioner an adequate opportunity to present documentary evidence, including specified documents, which were critical to proving title. d. That the court failed to consider material evidence, such as specify evidence, resulting in a miscarriage of justice. e. That the court's finding on jurisdiction is perverse, as it ignored the settled law that cite relevant legal principle or case, thereby exceeding its jurisdiction. f. That the impugned order is arbitrary and capricious, as it relies on specified effective reasoning or evidence, which is unsustainable in law. For prayer, in view of the above, the petitioner most humbly prays that this honorable court may be pleased to, a. issue a writ of certiorari to quash the order dated date passed by the civil court, district, in civil suit no. Number. b. direct the civil court to rehear the suit after affording the petitioner a fair opportunity to present evidence. c. grant any other relief that this honorable court deems fit and proper in the interest of justice. Annex Yours, Annexure A, certified copy of the impugned order dated date. Annexure B, copies of relevant documents, including specified documents. Annexure C, affidavit in support of the petition. Verification. I, petitioner's name, do hereby solemnly affirm and declare that the contents of the above petition are true to the best of my knowledge and belief, and no material fact has been concealed therefrom. Date, place signature, petitioner's signature or counsel's signature. 91 Advocate for the petitioner, advocate's name, enrollment number, contact details. Analysis of the draft. The drafted petition adheres to the procedural and substantive requirements for a writ of certiorari under Article 226 of the Constitution. Key features include jurisdictional clarity. The petition invokes Article 226, clearly stating the High Court's authority to issue the writ. Grounds of challenge. The grounds focus on jurisdictional errors and violations of natural justice, aligning with the principles in Surya Dev Rai v Ramchandar Rai. Relevance of precedent. The reference to Surya Dev Rai strengthens the petition by emphasizing the limited scope of certiorari to jurisdictional and legal errors. Procedural compliance. The inclusion of annexures, a verification clause, and counsel details ensures compliance with High Court rules. 92 Question 19, Drafting, Adoption Deed, Partnership Deed. Attempt any two of the following. I. Draft an adoption deed. 2. Draft a partnership deed. Adoption deed. Adoption in India is governed primarily by the Hindu Adoptions and Maintenance Act, 1956, HAMA, for Hindus, and the Juvenile Justice, Care and Protection of Children, Act, 2015, JJ Act, for secular adoptions through the Central Adoption Resource Authority, CARA. An adoption deed is a legal document that formalizes the transfer of parental rights and responsibilities from the biological or legal guardian to the adoptive parent, s. It must comply with statutory requirements, including consent, capacity, and registration, to be enforceable. Legal context and statutory provisions. Under Section 6 of HAMA, the adoption must be valid if the adoptive parent has the capacity and right to adopt, the person giving the child in adoption has the authority to do so, and the child is capable of being adopted. Section 11 mandates that the adoption ceremony, data homam, is performed for Hindus, though a deed can supplement this ritual. For non-Hindus, the JJ Act regulates adoptions, emphasizing the welfare of the child. The deed must include details such as the parties' identities, consent, and the child's particulars. A landmark case illustrating adoption formalities is Lakshmikant Pandey v Union of India, AIR 1984 SC 469. This case addressed inter-country adoptions, emphasizing the need for stringent documentation to prevent child trafficking. The Supreme Court mandated that adoption deeds must reflect the child's best interests, a principle that informs modern drafting practices. Specimen adoption deed. Below is a specimen adoption deed compliant with HAMA, suitable for a Hindu adoption scenario. Adoption deed. This deed of adoption is made and executed on this 15th day of June, 2025, at New Delhi, India, between Mr. Anil Kumar Sharma, aged 40 years, son of Mr. Ramesh Sharma, resident of 123, Green Park, New Delhi 110016, hereinafter referred to as the adoptive father, which expression shall include his heirs, executors, and assigns where the context so admits, of the first part. 93 and Mrs. Sunita Devi, aged 35 years, widow of Mr. Rajesh Kumar, resident of 456, Ashok Nagar, New Delhi 110018, hereinafter referred to as the natural mother, which expression shall include her heirs, executors, and assigns where the context so admits, of the second part. Whereas, a. The adoptive father is a Hindu by religion, married, and capable of adopting a child as per the provisions of the Hindu Adoptions and Maintenance Act, 1956. B. The natural mother is a Hindu by religion, a widow, and the sole legal guardian of the minor child, Master Rohan Kumar, aged 5 years, born on March 10, 2020, hereinafter referred to as the adopted child. C. The natural mother, due to financial constraints and inability to provide adequate care, has expressed her free and voluntary consent to give the adopted child in adoption to the adoptive father. D. The adoptive father has no biological male child and desires to adopt the adopted child to perpetuate his family lineage and provide care and upbringing. E. Both parties have agreed to formalize the adoption through this deed, in compliance with the provisions of the Hindu Adoptions and Maintenance Act, 1956, and have performed the necessary ceremonies, including Data Homam, on June 14, 2025. Now this deed witnesseth as follows: 1. Declaration of adoption, the natural mother hereby gives, and the adoptive father hereby takes, Master Rohan Kumar in adoption as his lawful son with effect from the date of this deed. 2. Rights and obligations, the adopted child shall have all the rights of a natural-born son of the adoptive father, including inheritance rights, and the adoptive father shall assume all parental responsibilities towards the adopted child. 3. Consent, the natural mother declares that her consent is free, voluntary, and without any coercion, undue influence, or consideration. 4. Severance of ties, all legal ties between the adopted child and the natural mother or her family are hereby severed, and the adopted child shall be deemed a member of the adoptive father's family for all legal purposes. 5. Registration, this deed shall be registered with the Sub-Registrar of Assurances, New Delhi, as per applicable laws. 6. Revocation, this adoption is irrevocable, and neither party shall challenge its validity except as permitted by law. In witness whereof, the parties hereto have set their hands and seals on the day and year first above written. Signed, sealed, and delivered by the within named adoptive father, Mr. Anil Kumar Sharma. Signed, sealed, and delivered by the within named natural mother, Mrs. Sunita Devi. Witnesses, 94-1. Name, Mr. Vikram Singh. Address, 789, Vasant Vihar, New Delhi 110057. Signature, to name, Ms. Priya Gupta. Address, 101, Saket, New Delhi 110017. Signature, analysis of the adoption deed. The above deed incorporates essential elements, identification of parties, recitals, whereas clauses, outlining the context, operative clauses declaring the adoption, and provisions for consent, rights, and registration. The reference to Data Homam ensures compliance with HAMA, while the severance clause aligns with Section 12 of the Adoption Act, which mandates that the adopted child is deemed a child of the adoptive family. The deed's enforceability is strengthened by witness signatures and clear consent, preventing disputes as seen in Karta Singh v. Surjant Singh, Air 1974 SC 2161, where ambiguous adoption documentation led to inheritance conflicts. Partnership deed. A partnership deed is a legal agreement between partners that defines their rights, duties, profit-sharing ratios, and other terms governing the partnership. Governed by the Indian Partnership Act, 1932, it is not mandatory but highly recommended to avoid disputes. Section 4 of the Partnership Act defines partnership as a relation between persons who have agreed to share profits of a business carried on by all or any of them acting for all. The deed serves as evidence of the partnership's terms, especially in disputes, and is essential for registration under Section 58 of the Partnership Act. Legal context and statutory provisions. Section 11 of the Partnership Act allows partners to determine their mutual rights and duties through a contract, subject to the Act's provisions. The deed must specify the firm's name, place of business, capital contributions, profit-sharing ratio, and dispute resolution mechanisms. Registration of the partnership firm, though optional, provides legal advantages, such as the ability to sue third parties under Section 69(2). A notable case is Cox v. Hickman, 1860, 8 HL Ca 268, a common law precedent influencing Indian jurisprudence, which clarified that profit sharing alone does not constitute a partnership unless there is mutual agency. In India, Malakshmi v. Shwarapa, Air 1995 SC 1948, underscores the importance of a clear partnership deed to establish mutual obligations, particularly in disputes arise over profit distribution. 95 Specimen partnership deed. Below is a specimen partnership deed for a general business partnership, /text partnership deed. This deed of partnership is made and executed on this 15th day of June 1st. /text Mr. Rahul Gupta, aged 35 years, son of Mr. Sanjay Gupta, resident of 321 2. /text Ms. Neha Kapoor, aged 32 years, daughter Mr. F. Anil Kapoor, resident of M, collectively referred to as the /text partners and individually as a /text, whereas a. The partners desire to form a partnership to carry on the business of /text Ptb. The partners have mutually agreed to contribute capital, share profits and losses. C. The partners intend to reduce their agreement into writing to ensure clarity and a /text. Now this deed witnesseth as follows: 1. /text name and place of business, the partnership firm shall be called /text. 2. /text commencement, the partnership shall commence on June 15, 2025, and shall 3. /text capital contribution, the first partner shall contribute Rs 10,00,000/4. /text profit and loss sharing, the profits and losses of the firm shall be Shar 5. /text management, both partners shall actively participate in the management, a 6. /text salaries and interest, the first partner shall be entitled to a monthly S7. /text accounts, proper books of accounts shall be maintained and audited annually. /text dispute resolution, any dispute arising between the partners shall be Res 9. /text dissolution, the partnership may be dissolved by mutual consent or as per 10. /text registration, the partnership shall be registered with the registrar of /text in witness whereof, the partners have set their hands on the day and year 5 /text signed and delivered by, 1 first partner, ______________________ Mr. Rahul Gupta 2. Second partner, Ms. Neha Kapoor 96 /text witnesses 1. Name, Mr. Amit Verma address, 987, Lajpat Nagar, New Delhi 110024 signature, __________________________________________________________________ Name, Ms. Shalini Rao address, 456, Vasant Vihar, New Delhi 110057 signature, analysis of the partnership deed. The partnership deed includes critical clauses such as name, capital, profit sharing, and dispute resolution, ensuring compliance with the Partnership Act. The provision for arbitration aligns with modern practices to avoid litigation, as highlighted in Malakshmi v. Shwarapa. The deed's clarity on mutual agency and management responsibilities mitigates risks of disputes, as seen in Prem Nath v. Dindale, Air 1938 All 217, where an unregistered partnership led to enforcement issues. 97 Question 20, Define conveyancing and different modes of conveyancing. Define conveyancing. What are the different modes of conveyancing? Definition of conveyancing. Conveyancing refers to the process of drafting, executing, and registering legal documents that facilitate the transfer of property rights or interests from one party to another. It involves the preparation of deeds, agreements, and other instruments that create, modify, or extinguish legal rights in movable or immovable property. The term derives from the historical practice of conveying property through written instruments, ensuring clarity and enforceability of transactions. In the Indian legal context, conveyancing is governed by statutes such as the Transfer of Property Act, 1882, TPA, which defines the modes of transferring property, and the Indian Registration Act, 1908, which mandates registration of certain documents to ensure legal validity. Conveyancing extends beyond property transfers to include agreements like leases, mortgages, and partnerships, which involve rights and obligations related to property or business. The Supreme Court in Raj Narain v. State of UP, Air 1957 SC 186, emphasized the importance of precise drafting in conveyancing to avoid ambiguity, underscoring its role in preventing disputes. Conveyancing can be broadly categorized into two types. Common conveyancing involves routine transactions like sales, mortgages, and leases, where standard formats are adapted to specific circumstances. Special conveyancing involves complex transactions requiring customized drafting, such as trusts, wills, or corporate agreements. The essence of conveyancing lies in ensuring that the document reflects the parties' intentions, complies with legal requirements, and is enforceable in a court of law. It requires a deep understanding of substantive law, procedural requirements, and judicial precedents to safeguard the interests of all parties involved. Modes of conveyancing. Conveyancing encompasses several modes, each corresponding to a specific type of property transaction or legal instrument. These modes are primarily governed by the TPA, which outlines the legal framework for transferring property rights. Below, we discuss the principal modes of conveyancing, their statutory basis, and practical applications, supported by relevant case law. Sale. A sale is the transfer of ownership of immovable property in exchange for a price paid or promised, as defined under Section 54 of the TPA. The conveyancing document for a sale is a sale deed, 98, which must include details of the parties, property description, consideration, and transfer of title. The deed must be executed, attested, and registered under the Indian Registration Act, 1908, to be legally valid. Example, in a sale of a residential plot in Delhi, the sale deed would specify the vendor, purchaser, plot dimensions, location, consideration amount, and any encumbrances. The deed must be signed by both parties and witnessed by at least two persons. Landmark case, Commissioner of Income Tax v. Burnja Kolko, Air 1959 SC 254, clarified that a sale deed must unequivocally transfer ownership. In this case, a defective deed lacking clear transfer language led to disputes over tax liabilities, highlighting the need for precise drafting. Mortgage. A mortgage involves the transfer of an interest in immovable property to secure a loan or obligation, as defined under Section 58 of the TPA. There are 6 types of mortgages, including simple mortgage, usufructuary mortgage, and equitable mortgage, each requiring a specific conveyancing document, typically a mortgage deed. The deed outlines the mortgager, mortgagee, property details, loan amount, interest rate, and repayment terms. Example, for a simple mortgage of a commercial property in Mumbai, the mortgage deed would detail the loan amount, interest rate, repayment schedule, and the property offered as security. Registration is mandatory for mortgages involving immovable property, Section 59, TPA. Landmark case, Ram Saran Lal v Dominique Ur, AIR 1961 SC 1747, addressed disputes over mortgage redemption, emphasizing that a mortgage deed must clearly define the rights and obligations of both parties to prevent ambiguity in enforcement. Lease: a lease is the transfer of a right to enjoy immovable property for a specified period in consideration of rent or other payment, as per Section 105 of the TPA. The conveyancing document is a lease deed, which specifies the lessor, lessee, property details, lease term, rent, and termination conditions. Leases exceeding 1 year require registration under Section 17 of the Indian Registration Act, 1908. Example: a lease deed for a commercial office in Bengaluru would include the lease duration, e.g., 5 years, monthly rent, maintenance obligations, and clauses for renewal or termination. Landmark case: Pradeep Oil Corporation v Municipal Corporation of Delhi, AIR 2011 SC 1862, highlighted the importance of clear lease terms. The court ruled that ambiguous clauses in a lease deed regarding renewal rights led to prolonged litigation, underscoring the need for precise conveyancing. 99 Exchange: an exchange involves the mutual transfer of ownership of one property for another, as defined under Section 118 of the TPA. The conveyancing document is an exchange deed, which must describe both properties, the parties involved, and any additional consideration, if any. Like a sale deed, an exchange deed requires registration. Example: if Party A exchanges a plot in Chennai for Party B's apartment in Hyderabad, the exchange deed would detail both properties' descriptions, valuations, and mutual consent to the transfer. Landmark case: Jaturam v Hakam Singh, AIR 1994 SC 1653, clarified that an exchange deed must reflect mutual consent and equal valuation of properties to be enforceable, as disputes arose due to unequal valuation in the case. Gift: a gift is the voluntary transfer of property without consideration, as per Section 122 of the TPA. The conveyancing document is a gift deed, which must include the donor, donee, property details, and a declaration of voluntary transfer. Registration and acceptance by the donee are mandatory, Section 123, TPA. Example: a gift deed transferring a house in Kolkata from a father to his daughter would specify the property, the donor's intent, and the donee's acceptance, duly registered. Landmark case: K. Balakrishnan v K. Kamalam, AIR 2004 SC 1257, emphasized that a gift deed must demonstrate the donor's clear intent and the donee's acceptance, as disputes arose over an unregistered gift transaction. Will: a will is a testamentary document that conveys property upon the testator's death, governed by the Indian Succession Act, 1925. While not a transfer during the testator's lifetime, it is a critical mode of conveyancing for posthumous property distribution. The will must identify the testator, beneficiaries, and property, and comply with Section 63 of the Succession Act, execution and attestation. Example: a will bequeathing a family estate in Punjab to 3 children would detail the estate, the testator's intent, and the shares of each beneficiary, attested by 2 witnesses. Landmark case: Nanambal MLVT Rayu IR, AIR 1951 SC 103, underscored the importance of clear drafting in wills to avoid ambiguity, as disputes arose over vague beneficiary descriptions. 100 Trust: a trust involves the transfer of property to a trustee for the benefit of beneficiaries, as per the Indian Trusts Act, 1882. The conveyancing document is a trust deed, which specifies the settlor, trustee, beneficiaries, trust property, and purpose. Registration is required for trusts involving immovable property. Example: a trust deed creating a charitable trust for education in Delhi would detail the trust property, e.g., land, the settlor's intent, and the trustee's duties. Landmark case: Commissioner of Income Tax v JK Charitable Trust, AIR 1992 SC 193, highlighted that a trust deed must clearly define the trust's purpose and beneficiaries to qualify for tax exemptions. Partnership. A partnership deed, governed by the Indian Partnership Act, 1932, is a conveyancing document that outlines the terms of a business partnership, including capital contributions, profit sharing, and management duties. While not a direct property transfer, it involves rights in business assets, making it a mode of conveyancing. Example: a partnership deed for a retail business in Mumbai would specify the partners' capital, profit-sharing ratio, and dispute resolution mechanisms. Landmark case, Malakshmi v. Shwarapa, Air 1995 SC 1948, emphasized the importance of a clear partnership deed to establish mutual obligations, as disputes over profit distribution arose due to an ambiguous agreement. Power of attorney. A power of attorney, POA, is a document authorizing an agent to act on behalf of the principal, often for property transactions, as per the Powers of Attorney Act, 1882. It is a mode of conveyancing when used to execute property-related documents. Registration is required for POAs involving immovable property transactions. Example: a POA authorizing an agent to sell a property in Bangalore would specify the principal, agent, property, and scope of authority, duly registered. Landmark case, Sarai Lamp Industries Private Limited v. State of Haryana, Air 2012 SC 206, cautioned against using POAs to circumvent registration requirements for property transfers, emphasizing the need for proper conveyancing. Practical considerations in conveyancing. Effective conveyancing requires adherence to statutory formalities, such as attestation, registration, and stamp duty payment under the Indian Stamp Act, 1899. The drafter must ensure clarity, 101 avoid ambiguity, and anticipate potential disputes. For instance, including recitals, whereas clauses, in deeds provides context, while operative clauses define the transaction's legal effect. The use of precise language, as seen in Raj Narain v. State of UP, prevents misinterpretation. Conveyancers must also verify the title of the property to ensure it is free from encumbrances, as disputes over defective titles can render deeds void, as illustrated in Anand Nevis Private Limited v. Anandji Kalyanji Trust, Air 1965 SC 414. Additionally, compliance with local laws, such as municipal regulations for property transfers, is crucial. 102.